this experience help to bring awareness of how we can stimulate the action based in data. So I'm more than happy to be here with you. So
a very good morning to everyone. I welcome you all to the second day of the International Colloquium of Criminal Justice in Numbers. I extend a warm welcome to Ms. Erendra Gonzalez. Erendra brings her passion for social research and quantitative studies to the Justice Project. She specializes in data collection and survey methodologies, questionnaire design, and public opinion analysis. For 6 years, she led the quantitative research division of a polling firm working with a variety of clients like the World Bank, the Inter-American Development Bank, Innovations for Poverty Action, and many other. So I welcome you, ma'am. For the session, we have Ms. Maja Daruwala and Valay Singh as discussants. So if we may please begin the session. Thank you.
thank you so much. Thank you so much for the invitation. Thank you for all the organizers, and hope all my experience with the Mexico Index, Rule of Law Index, helps to bring awareness to what we can do with the data. So first of all, I want to, let me expand the presentation, but let me introduce really quickly what we do in the World Justice Project. Basically, World Justice Project is an organization that is based in Washington, D.C., with offices in Seattle, in Singapore, and Mexico City. I personally work in the Mexico City office. And our mission is to work to advance the rule of law worldwide. We have three main objectives in the organization. The first one is to create knowledge. The second one is build awareness about the rule of law adherence worldwide. And the third one is stimulate the action that based on the data that we have created. So basically, that's our general overall mission. How we do that? We do that our work based in the Rule of Law Index. That's our main product. We try to provide information of a very heavy topic, which is rule of law, trying to disaggregate this topic in different dimensions that can provide us a better understanding of the rule of law. So how we do that? We collect data based on the experience and perceptions of these dimensions of rule of law among population and among experts in more than 130 countries worldwide. These dimensions that I mentioned are related with checks and balances, corruption, open government, fundamental rights, order and security, regulatory enforcement, and civil and criminal justice. So all this information collected use, as I mentioned, surveys that we collect with general population in their households. And we also have an amazing database with specialists around the world that are specialized in criminal justice and civil justice, including administrative justice, commercial justice, and labor justice. We also include information from a public health specialist. So this is the main methodological arc of the rule of law index. We have these 8 dimensions, as I aforementioned. So what do we see at the global part? First of all, we see in the last year, we measure, as I mentioned, more than 130 countries, and we saw a big gap between the countries. So I'm not a specialist in Indian policy. I don't know the context specific of India, as you may know. Surely you know, but what I can tell is what I can see in the global index. And I know that you won't forgive me if I don't present any information about India. The first thing that we could see is India is ranked in the 79th position among all the countries. And what we have seen is a slightly decline from the previous year. Where is Mexico? Mexico is in a similar position, also declined from the previous year, but we are not doing so well. We are in the position 113. So we are below that point. Some general trends in the global index. The first one is, that, as you may see here, in just one image, we can see that most of the countries are in the middle of the scale in the adherence of rule of law. We measure the rule of law in a range, we put the score in the range from 0 to 1, when 1 signifies we are the highest scored or the strong adherence to the rule of law, and the 0 means that we have the lowest score. As you may see, we have this scale in colors, with the red is the lowest part and the greenish is the strongest part. And we can see that the world is in yellow, orange thing. So we are in the middle, we are not doing so well, but we have a wide gap between the countries. General trends that we can see the last year. The first one is that we have seen some declines in constraints on government powers. This information was collected the previous year, in 2021, with some information that happens during the COVID during the COVID restrictions. So we saw that 70% of our countries decline in constraints on government. This includes India. Second trend that we see, we have seen a tendency to close the civic space during the previous year. When we say closing the civic space, we mean, first one, a decline in the participation, of the civic participation. The second one is a decline in the freedom of opinion and expression. And third one is a decline in freedom of assembly and association over the world. This includes also India in this tendency. The third trend that we see the previous year is delays in civil justice and criminal justice and administrative proceedings during COVID. So we saw this, that the people experience delays during their judicial process, who impacts in three of our dimensions: the civil justice dimension, the criminal justice dimension, and the rule enforcement dimension. So these three trends that I mentioned are similar to what we have experienced in Mexico. So now I'm going to speak more of the topic that I could say a little bit more, and it's the Mexico State's Rule of Law Index. 5 years ago, WJP started this work to try to understand not just the difference between countries, but also try to understand how the dynamics of the rule of law works inside a country. And Mexico brings a perfect laboratory for that, because we have plenty states that are different and that work with the same context and the same line base to start, but also have different approaches and a lot of multicultural differences. So 5 years ago, we start this project which is a Mexico State's Rule of Law Index. We set 3 objectives in our projects. The first one is related with justice. We try to know a little bit more about the effectiveness of an access to the criminal and the civil justice systems. The second is the governance. We work with a lot of transparency, accountability, and corruption institutions here in Mexico. And the third one is with the private sector. We work with the impact, with the law enforcement, how the law enforcement affects in the business environment. All these projects are based in the results of the Mexico State's rule of law. So what is the Mexico State's rule of law? We are based basically in the methodology of the global rule of law index, but we adapted to allow us to reflect better the structure of the Mexican dynamics in the government, the 3 branches that we have in the country, and some of the specifics of our country. We also have more data that we can include to our index. One of the main difference between the global index and the Mexico index is that one of the sources, which is the third-party sources, are more available at a country level than a worldwide level. So we can include more different third-party sources to our data. One of the things that has been kind of complicated to communicate here in Mexico is that the global index, it's not comparable with the Mexico State's index because methodological issues. At some point, as we will see later, it will start to be a challenge with the narrative that we want to sustain related with the performance of the government. But we will try to make all the time clear that we are not evaluating any particular actor, any particular government, or any particular policy. That's the way that we try to manage the narrative against this confusion between the global and the Mexico State's index. So what have we done in these years? Today, we have four editions of the index, and we have been well received. So how we have done all this path to create the index, to make this tool as a policy instrument for local governments. As I mentioned, we have, as an organization, three specific objectives. The first one is create knowledge. In this case, as I mentioned, we have the Mexico State index. We collect all the data. We have more than 12,000 surveys around all the country. In Mexico, we have 32 states. We collect 400 surveys at face-to-face, 400 per each state. We also have a database with more than 16,000 specialists, which is mainly lawyers, specialists in civil justice, labor justice, criminal justice, and public health. And we sent an email invitation to answer our survey. And the last year we get 2,000, almost 2,200 surveys completed with the local experts. The third source that we have and we collect are the third-party sources. These information are are data that we collect from administrative data or surveys that are created by other institutions. But the thing is that we try to balance who are we getting this information. We get information from the government, we get information from autonomous institutions like the National Transparency Agency here in Mexico, and we also include information from academia and from NGOs that are more specialized in some topics that we can ever get from our end. So these are one of our strengths, that we can manage to balance the information that we get, collecting the experience of everyday people, collecting the inside information of a specialist that lives the everyday, the ups and downs in the justice system. And we also include information from the government and other agencies that have trust from the people and from the government that the data are robust. So the second work that we have done is partnership. Partnership with, in particular, with two bodies. The first one is the National Transparency Agency, which is the INAI. I wrote that. They produce every 2 years the Open Government metric in Mexico. So this is one of our third-party sources. With the entrance of the president of Mexico 2 years ago, a couple of years ago, these sources are in doubt if they're going to produce one more year. So we reach out to try to make this metric happen again. In this work that we held with the INAI, a lot of organizations.
Yes. Sorry, Ms.
Yes.
Surendra. Just 10 minutes are left, please. Thank you.
Yeah, thank you. During this work with INAI, we get to know a lot of institutions that also are eager to get more information about open government, but also about the openness in the justice system in Mexico. And we find a void of information there. I'm going to go deeper into that further. The second partnership that we get was with legal and public health organizations. These organizations help us to create a network with a lot of lawyers around the country. The third part in this production of the index are, as it is, the production of the report. We calculate and we validate all the information with specialists, with the government to just check all the informations. We make cross checks with other third-party sources, and we'll make this transparent so the people can see all the process. That provides a lot of trust. What we have seen in Mexico, I won't stay along in this, but as you can see, the trends that we see in Mexico are similar to the trends we have seen in the general context, in the global context. We see a wide gap between the strongest rule of law adherence in Mexico. We saw a continued stagnation even some deterioration among the states in Mexico, declining checks and balances, deterioration of the judicial system, but a third one that is different, which is a stagnation in anti-corruption controls. This trend was one of our main challenge to communicate, because anti-corruption fight was and is still one of the main or one of the key issues that the president government are pushing to combat. So we see that as stagnation. All the policy that they have done in these 3 years are not getting reflected there. We can see that in Mexico. This is basically the scores and the rankings in our country. As you may see, we are in the middle, in the lowest and the middle part. We don't even have any greenish state. The second thing that we want to do in the process is the launch of the data, how we disseminate the information, the insights. We create this network with what we will call the champions of the rule of law, which are high-level decision makers in Mexico. And we connect with them and manage to bring an event to present all the data that we have done with the index and present in the All Senate House with high-level actors in the political panorama. We try to include all the political groups, including the president's political party, representatives. We also have events with the Mexican Bar Association and other lawyer associations. And we are going to, we are actually doing that, presentations with authorities at the state level. We are meeting with governors and with other key actors in the state level government to present our data. We create different materials and communication materials, specialized to communicate the information that we want for targeted audience. We use the media to amplify our message with a low cost, this is a low cost marketing, because the key actors, the governors, the senators that start to replicate the message, amplifies in the media. They get the attention that we can even get by ourselves, and they start to spread the message, and they focus all the time in opening these spaces to start to put attention on the rule of law, and how can we strengthen our scores in this area. The third thing that we have is a collaborative research on rule of law. As I mentioned, we work closely with INAE, and we found that there is a void of information related with open justice. So we decided to co-create an open justice metric, which will be the national official policy instrument aimed to set and assess the standards of transparency, accountability, or responsiveness on the justice institutions and the services of justice that the citizens receive. WJP will lead the technical component of this metric. And this is an innovation at the national, but also at international level, to try to bring the open government principles to the justice system. At the end, we have bring all this information at a policy level, but that is I think, our greatest accomplishment or our greatest achievement to stimulate the action. With all this work that we have done, we start to engage a lot of champions that are interested to get information. So, as you may see in the left side, this is our policy reach. All these states have decided to include our data in their planning instruments to measure how the government is doing around different parts of the rule of law included in our metric. So they are waiting for our data to measure how they are doing during their how they are performing. This this engagement that we get, it's not just that we are just knocking the doors. Sometimes we have just one person in all the government interested in the data, and we just start to make all the materials, all the information available, but also that is easy to understand and to have a path of what they can do based in the interest of each government, because not all the states have the same problems, and not all the governments have the same priorities. So we design a fit specifically path of what they can do and what they can change. Also, we have this targeted engagement, which of course is in this case with the open justice metric that we want to do. We need to engage the justice institutions in Mexico. So we start to make some agreements and sign some memorandum of understanding with different institutions in Mexico. The most recent one was with the Federal Supreme Electoral Court in Mexico, just to sign up to provide information and to validate the open justice policy. So just to close this presentation, some of the challenges that we have done. I separate this in three main challenges. The first one is the methodological, which is something that we have to acknowledge, that we have limitations. One of the biggest limitation is that we are not specific enough to provide the causation of the declines or the strong parts of the index, why we have what we are showing. But acknowledging that has been one of the strengths, our strengths during this process, because allow us to collaborate with the governments to try to find the causations. We also have some limitations related with the data we collect, because as you may know, the public opinion can change rapidly, so we can't control that at some specific point. The third challenge that I recognize is that we are based a lot in the specialist data. And this can bring some problems of measurement when we don't have a strong number of responses. And we have tried to amplify our sample, included or having these meetings with bar associations to include more specialists, but also to make more diverse our sample, including more women lawyers or indigenous lawyers to make more and a stronger sample. Another challenges that I have noticed is in the politics side, but also at the policy side. In the politics side, last year we have, I know, we were mentioned in a national stage by the spokesperson of the president here in Mexico, and he issued the poor performance that we have shown in our index. That implies or they imply that we maybe have motivations, political motivations, or that we are biased, and put in doubt our robustness of the robustness of our data. We have the risk that WUEP start being perceived as politically motivated, or maybe that we could be in the middle of this polarization in Mexico. Another challenge is at the policy side, because we have a great policy reach among the states, but last year we get that 70% of the states now are the governors of the 70% of the states now are from the president's party, and they will be aligned to their position. So we risk to lose our policy footprint in the states. We risk to lose our public position as a credible institution and a reliable institution to be a policy partner among all this work that we have done. How, in general, did we overcome that challenge? I see three main things. The
Ms.
first one
Gonzalez,
is
I'm really
the
sorry.
conceptual and methodological
Really sorry to
robustness.
interrupt.
Sorry?
Ma'am, time is up, ma'am. I now invite the discussants to please ask the questions.
If you can let me, that's the last one. Just,
Sure, ma'am, sure.
yep. The three things that I foresee here is, the first is try to rely on our robustness as a methodological organization. The second one is to bring a collaborative and non-confrontational approach. We always prioritize the dialogue. We understand the challenges that the government and the officials in the government has to overcome. And we try to provide all the information, and we try to provide policy-oriented research. And the third one is networking and presentations with high-level decision makers that amplifies the message, but also allow us to partner, to engage, and to get more contact with the governors, and this is kind of domino effect that brings the attention of other governments, and they raise your hand and try to get in contact with us to make changes. So that's it, basically. So now, if you want to proceed. Thank you very much.
Thank you very much, Arindira. It was quite enriching for us here in India. Although the governance structure is not exactly the same, I think many other factors are similar, including the prevailing political context in both our countries. So given that we are already running behind on our schedule, I would keep my comments very brief, and I would just say that not drawing a comparison with the India Justice Report, which is in a way a hat tip to the World Justice Project's Rule of Law Index itself. What we do here is we avoid totally the survey-based data collection, because it has room for what you also say about questions of credibility and bias. So we only rely on government data, and but the idea is the same. Our many people in the room here are also working on data-based advocacy in the justice sector. So I would, unless Maya has a comment, otherwise I would like to open this to any questions or comments that people might have in the room. Otherwise, I'll come back and ask my own questions.
Thank you. I would like to open it for questions from the floor. for as long as our moderator will tell us. And I can make one or two closing remarks if that's okay. Does anybody have questions? Sir,
Yeah.
please.
Ma'am, could you just elaborate a bit on the National Institute of Transparency that you have? Because I think that's something which is to be compared, because here also in India we have something like, CVC or, things like that. So just wanted to have some brief idea about the National Institute of Transparency that you have. Is it a governmental body or like how exactly it works? That's what we wanted to know.
It's a governmental body, but it's autonomous. They don't respond to the government, to the executive government, but is part of the government body. They provide the guidelines and they enforce the states and the federal government to provide all the information and ensure that they follow the rules of transparency and access of information to the citizens. They also help to the citizens to match the information that they want. They are part of a digital platform that are created here in Mexico to make available all the information that by law is marked to be public, and try to make it accessible to the people, because we have a lot of data and a lot of public data, but the problem is that nobody uses, because it's complicated to use for different situations. And sometimes it's something as basic as we have just a copy and a PDF that we can do anything. But also sometimes the information is massive and the people don't know what to do. So they try or make that effort to translate this volume of information in something that people can understand. So basically, this institution has the political side of make that connection between citizens and the government. To be honest, the last couple of years, it has been hard for this institution because I mentioned that the anti-corruption fight was one of the main flags of the government, but also they are not so keen to open the information. So they have been hard work to do this couple of years, but that's why this open justice line that we start to work with them was an amazing route, because the justice branch is one of the branches of, actually is the branch that still perceive as autonomous, as independent, sorry, and have a high level of opinion or estimate from the population. So that it's a side that they start to bring.
Please. Yeah.
Arindra, how do you control bias in your own sample? Like the people you interview, the lawyers, I mean, what are the ways to check for bias in that sample itself?
We have a different checks and validations process. The first one is when we select the survey. We make sure that this sample that we have with 16,000 of specialists are not part of the government, so they don't have to any opinions that can be or maybe biased. We also check, we make backup checks just to know that the specialists that answer the surveys don't have any illegal background or any scandalous or any anything that could be of worry for us to that can bias their answers. Also, we have this problem with the sample that could be itself biased, that have this kind of error of be biased. Why? 60% of the lawyers in Mexico are male, are city-based, and this provides a little bit of bias itself. So what we try to make is to get in contact with the specialists in not only in urban areas, but also in rural areas. We also try to amplify our sample to include women, because 60% are male in terms of the universe of specialists in Mexico, of lawyers in Mexico, but our sample at the beginning of the creation of the index has a distribution of 20% of women versus 80%. So we managed to include more women in our service. Also, we start to create different strategies to get in contact with specialists that are in states that have serious problems with security, because lawyers and public health, basically doctors, try to be more, try to care a lot of their data. And it's not so easy to find them because they don't provide an email or even a telephone. So we have to make this snowball sample. When we find one lawyer in one state, we try to get in contact with different colleagues through that specialist. That has been helpful to increase our sample in states that traditionally are not so visible, the lawyers in the states. We also have different difficulties sometimes getting in touch with lawyers that are not used to use their email. So we start to make phone calls and try to make them to answer the survey with a telephone interview, if that's the case. So basically, that's the way we try to overcome and to compensate some biases in our survey, especially with the specialists.
I think that's, Erin, thank you so much for being here and talking to us about the World Justice Report as well as the Mexico report. It has many, many facets which resonate with a lot of people who are sitting in the room, both who do surveys as well as those of us who look only at data. With the same problems with having done all of the work, getting it out into the public, getting the public to believe it, and for policymakers as well as everybody else to amplify it and then to use it. That is always the uphill task. The only one comment I wanted to make, which I want to sort of put to the room as quite a provocation, is you said that when you were showing us the world map, that the world is yellow. That is to say that the belief in the rule of law is nowhere. There's hardly, and yet we are governed by an international order which is taken from the Universal Declaration of Human Rights. And so we assume, and those were taken because we thought that these were universal values that were based and every heart had them. But now we are finding that convenience, the politics, the way economy is run, etc., that the rule of law notion is not widespread, not implemented, not practiced. So does that make it illegitimate? I'm going to leave that question with you because everybody in this room is working toward making that into the majoritarian view on the assumption that it is the legitimate and majoritarian view.
Oh, that's a great question, an amazing question. We rely that what of the thing of the rule of law, I think, is the capacity to bring communities of peace, but also to provide equal opportunities among the population. And I think this is, I know it's not in the same level that the public opinion about the rule of law, but I think the well-being of the population has been a priority in this part, and one of the main benefits and positive things of the rule of law. So I think that's part of the message that has to be divulgated, that the opportunities, that the access to justice, that the transparency of information, the accountability are values that must be to be protected, because that will help to bring all the population, not just to amplify the gap between the richer and the poorer people.
Thank you. Thank you very much for being with us.
No, thank you so much for the invitation. And I'm apologize for the confusion yesterday.
We'll begin with the next session, please. The topic for the next session is A Decade of POCSO, Insights from Judicial Data. Presenter is Apurva for Legal Policy, and Mr. Ankit Kaushik, Assistant Professor, RGNUL, will be the discussant. for cases that had been tagged to the POXO Act were things like Negotiable Instruments Act, were things like civil suit, which cannot be a POXO case under any circumstance. Then when we were looking at disposal data, you would assume that a POXO case is a criminal case would end in acquittal or conviction. But that is not the case. There are hundreds of variations in which the outcomes of POXO cases have been entered in equals. Then when we were looking at hearings data, the purpose of hearing became a little unclear because the hearings table on equals doesn't tell you about what has happened at that particular hearing in reality. Now I'll come to some of our findings. Now, since we have to be very careful when we're dealing with ECOTS data, there are going to be a lot of caveats during my presentation. The first is when we talk about reporting on ECOTS, let's not confuse this with incidents. We are not saying that Delhi has the highest number of POXO cases in the country. We are saying it has the highest number of cases that are reported on ECOTS. And with crimes like POXO that often which are offenses of child sexual abuse against children, they often go unreported. And in a way, if they are being reported and they're being entered on ECOTS, that we can take as a positive sign. So according to this, so these numbers have been adjusted for populations of different states. And what becomes evident is that there is a huge variation between states in just how many cases on POXO are reported across states. Then coming to the next slide, and you would see that Delhi, Chandigarh, and Sikkim have some of the highest reporting of POXO cases, and Kerala. Coming to district-wise reporting. Now in this, we've looked at interstate variation, but there is a lot of interstate variation in POXO as well. For example, in Assam, the reporting on ECOTS is varying at 1 per 100K, 1 case per 100K in Barpeta to 40 cases per 100K in Moregaon. In Himachal, it's less than 1 case in Kulu per 100K, but 90 cases per 100K in Kinnaur. And that different districts have different needs, and we can't have a one-size-fits-all approach to deal with the problems that different districts are facing. And also, like some of the highest, districts with the highest reporting are like Namchi in Sikkim, which has 510 cases per 100K. Then New Delhi, of course, features, and Central Delhi. And then it's diversified. The point is that it's not one state or one district that is the problem. There are incidence varies across the country, not incidents, reporting on ECOTS. Coming to the next slide, which shows you the disposal pattern in POXO cases. 43% of our cases ended up in acquittal and conviction was about 14%. Now we had about 717 outcomes to choose from. And those we categorized into different categories. Some we put as acquittal, some we put as conviction. But what is concerning here is that transfer is constituting a very huge percentage. Now, POXO is a special legislation that designates special courts. Why are cases not coming directly to the special court? That is a huge matter of concern. Then, coming to the next. We come to pendency and disposal across states. Now, this is overall pendency and disposal. So over the time period of the study, since the inception of the POXO Act, what percentage of the cases have been disposed of and what percentage are pending? So we have about, and again, there is a huge variation across states. So whereas like in an Uttar Pradesh, about 77% of the POXO cases that have been filed so far are pending, filed and reported on ECOTS are pending. In Tamil Nadu, they have disposed of 80% of the POXO cases that have come to them. So the variation across states is huge, and different states have to adopt different policies to deal with this. Coming to the next slide, this is pendency through the years. Now, this figure shows you two things. It shows you the total number of POXO cases, which is the red and the blue put together. And that shows you that it has steadily increased for the time period of study. But it also shows you what is the pendency percentage. Now, one thing is very clear is the impact of the pandemic.
because between 2019 and 2020, the pendency percentage shot up by 10%. So it was slowly declining. The number of the pendency percentage was on a slow decline till 2019, but the pandemic hit and in 2020 it jumped by 10%. Another thing that is important to note here is that despite 2020 being a pandemic hit year when most of the country was under lockdown, the number of POXO cases seems to have still increased. So that is actually a matter of concern. When everyone is in their houses or for a large part of the year, how is the number of POXO cases increasing? Um, Coming to the next slide, this is the average case length by state and year. This is a slightly complex diagram, but the purpose is to see what is the average time that is being taken by different states to dispose of POXO cases, and is that changing from year to year? So as we see, and as expected, as time goes on with every year, most states are taking more and more time to dispose of POXO cases, which means that the average case length is increasing. But the average case length in some states shows a very haphazard pattern. Sometimes it increases, then it decreases for a certain year, then it will again increase. But the problem here is that this includes all kinds of cases. If case length is even decreasing, it includes cases of transfer, which would have taken not much of judicial time. So this includes all kinds of cases. So which is why it's important to look at what happens in cases of convictions and acquittals. So there, what we notice is that in conviction cases, the time taken in most states is more than that is spent in acquittal cases, right? So apart from Sikkim, Kerala, and West Bengal, the time that is being taken for conviction is greater. But another thing that becomes very clear from this diagram is that in states like states or UTs like Chandigarh and West Bengal, these are the only ones that are taking less than a year to convict on average. POXO is a special legislation, and Section 35 of the Act prescribes that the trial should ideally be completed within a period of 1 year from the date of cognizance. But that is not happening across the country, and that will become clearer from the previous diagram. So what is happening here is that now this is the overall time taken for disposal, and it shows you the age composition of POXO cases based on their filing year. Now, what is happening here is that yellow represents cases disposed in less than 1 year, and it seems that that is on an increase. And it seems, and the purple here represents cases that take more than 3 years to be disposed of. And it seems that that is decreasing. And it seems that courts are becoming more efficient as time is going past in disposing of POXO cases. But if you look at it very carefully, and if you compare this with the filing data, what you will realize is that for a 2017, where the purple percentage is very small, and it seems like the courts were very efficient, and the cases filed in 2017, most of them were disposed of in less than 3 years. When we look at the filing data, we realize that of the cases that were filed in 2017, nearly 37% were not disposed of. So they are still pending at the point we last scraped the data. So this is only since this is by filing year, a lot of those cases have yet to be disposed of. So overall, if we look at this, more than 40% of the cases that were filed in 2017 have taken more than 3 years to be disposed of. So this is one way of saying that you have to be very careful in how you can interpret data, like, and especially equats data. Coming to one of the last slides, I want to talk about the time taken by different stages in a POXO trial. Now, as you will see, we looked at the number of days that are spent on a particular stage, and we looked at the number of hearings that are spent on different stages. And it is very clear that both with hearings and the number of days, the time that is being taken is on evidence. Evidence is consuming 40% of the time spent on a trial. And so that makes it very evident that we need to expedite the stage of evidence if we want to expedite POXO trial. But how that is supposed to be done, how that can be done, is something I'm looking to understand from everyone present here. Coming to finally this last slide. There is a slight mislabeling here, but the bars represent different provisions, sets of provisions of the POCSO Act. So the first bar, which is the highest bar, deals with cases of penetrative sexual assault. So that tells you that penetrative sexual assault cases are the most reported under the POCSO Act. Then you have aggravated penetrative sexual assault. Then you have sexual assault. Then sexual harassment. And then finally, you have aggravated sexual assault cases. So that is the sequence. But what is more troubling from this figure is that it looks at year-on-year trends in each of these offenses. And what is troubling here is that they're constantly increasing. So cases of aggravated penetrative sexual assault are increasing. Cases of penetrative sexual assault are increasing. And that is slightly troubling. Now, what are the key takeaways? Key takeaways from the study are that there is a need for uniformity and standardization in ECOTS data. As judicial reforms researchers, we've been saying this for a really long time. The ECOTS data is so rich, it has the potential to inform policy making in so many ways. But the way the data is entered, it took us months to just clean the data so we can analyze it somewhat. And even now we have to present so many caveats every time we represent this data because there are so many problems with how it has been entered. So one way to do this and to make this data more accurate would be to provide drop downs wherever possible. Like you cannot have a legislation represented in 688 ways. One legislation that makes it impossible to do any kind of analysis. And despite our best efforts, we could not capture data for the entire country because we could not identify all the possible variations. We know how many legislations there are in this country. We can easily provide a drop down and help the data entry operators just choose instead of having so many variations of the same law. Oh, it goes without saying we need to train our data entry operators well. And yeah, so these are some of the things that I wanted to add. And we need to increase the accuracy of ECOTS data and use it better. And till all of this happens, till all these aspirations are realized, we need to share our knowledge, share how we cleaned our data, share how we went about the process of organizing that data, making it more amenable to analysis. So yeah, with that, I would like to conclude this presentation. Thank you.
Okay, thank you, Ms. Apurva, for that very wonderful presentation. And I would also like to congratulate Vidhi on coming up with this report. When is this coming out? It'll be coming out in October. Like I'll be very sure to go through it at once. You know, very, very, very insightful. Some of the presentations, like the findings that you have, they're phenomenal, right? But I'll take a second and I'll move on. And what I'll do is I'll just encapsulate some of the problems with using the e-courts data in general as well. So here at Rajiv Gandhi National University of Law, we have recently started a project on mitigation and sentencing. So we are not just looking at death penalty, but we are also looking at how mitigation is playing a role in terms of sentencing in heinous offenses in general as well, right? Because at the end of the day, if a judge is relying on sentencing, he is going to be taking a look at aggravating and mitigating factors. So for that, we require both a macro and a micro level analysis of the data that is being provided to us by the e-courts. And we are running into several problems. And the issue is that it's not just us and it's not just Vidhi. Apurva has identified several problems that she had to face when she was, for example, coming when she was indulging in data cleaning, right? We're talking about data standardization. We're talking about data entry, and that's very important. And all of these problems are being faced by researchers who are using the e-courts data in some manner or the other, right? So there's this paper from 2020, which has emerged from the National Institute of Public Finance and Policy, the NIPFP. And I think these are one of the only researchers who have actually taken the pains of bringing it out like forward that, okay, these are the problems with the e-courts data. This is what the e-courts project, the Supreme Court committee needs to fix ASAP, right? One of the problems that was highlighted was the case types. So NJDG mandates that there are 24 case types overall. But that is not these are not the 24 case types that the district courts themselves are using in order to upload the data. These researchers found that the district courts uploaded more than 100 types of case types. They identified those case types into more than 100 categories. And then all of these categories, for the purpose of standardization, had to be rolled back into those 24 categories which were mandated by the National Judicial Data Grid. And the problem that this has created is that this leads to inaccuracies. This leads to the reliability and the scientificity of that data being taken away. And when we're dealing with empirical legal sciences, these are the two qualities that we require. This is what Professor Bajpayee was also talking about at the inaugural session itself. So and not only that, there are very substantive errors that can also be found in how these data entries are being made in the e-courts under the e-courts project, right? For example, if a case is recorded under the IPC, and that if a case is, or for example, with regards to 304B of IPC, and it's being prosecuted under the CRPC, the data entry the data entry operators will actually categorize that case as a CRPC case rather than an IPC case. So CRPC cases are essentially those cases which are registered under the CRPC. For example, 125 maintenance. But even IPC cases are being categorized now as CRPC cases. And sometimes even more substantive mistakes are being made in the sense that these researchers from the NIPFP, they found that entries from the Juvenile Justice Act, from the PWDV Act, and from the CRPC were found filed under commercial transactions, commercial disputes. Now, if these kinds of entries, if these kinds of mistakes are being made, then one wonders how reliable that data is for us as researchers, right? And this problem was also highlighted by the Internet Freedom Foundation, Apar Gupta. He also highlights this problem when they were trying to implement the zombie tracker. The zombie tracker was an initiative that they came up with that they were trying to look at, even though after Shreya Singhal 66A had been struck down, it was still being enforced, right? And they were trying to track in how many cases is this being enforced. At first, they had to manually download all of the cases relating to the IT Act in order to isolate those registered under 66A. Like, this was a major issue that they had to face. They had to manually click on each and every case that was registered under the IT Act, download that in one place. In terms of data standardization, however, they found that the term IT Act, Information Technology Act, it had been fed into the database in at least 8 different ways. So you've written that as Information Technology Act in small caps, and then Information Technology Act in big caps, and then IT Act, and then IT Act 2002. So there are so many variations in which that data was being fed that they had to manually identify, like Apurva, that to manually identify each and every one of these keywords that had to be input, that they had to input in order to be able to ensure that they have the complete database of all IT cases that are being filed, right? Another facet of this data standardization problem, it has been the issue of case identification by statute. They found that the NI Act also, it had been written down in almost 21 different ways. Right? The case types under those NI Act were also written down in at least 21 different ways. So when you're trying to work as a researcher, these are like very practical problems that you come up against. And when you're dealing with used databases, Apura was dealing with 4 lakh cases. The data development lab people, they were dealing with almost, I believe, 3 million cases, right? So when you're dealing with these large databases, it becomes it's almost impossible for us to be able to look at each and every single case on its own, right? Another problem with the e-courts data is that between 2008 and 2014, this was being implemented in phases, right? So this entire so there are cases with respect to some district courts, there are cases with respect to other district courts. And if a district court was onboarded in 2013, then if there is a case that has been filed in 2011, it'll only be mentioned in that data of the e-courts data only if there has been a hearing in 2013. if that case was resolved before 2011, it won't find a mention in the e-courts data, even though apparently we are talking about data from 2008 onwards, right? So this was another issue. There are also missing data entries, right? We're talking about missing data, final orders themselves are missing. The NIPFP people found that the final orders themselves were missing in almost 70% of the cases. So even if you want to cross-check the metadata and the case data that is being provided by the e-courts online, with the final orders of the case in order to see if they have actually been able to, record that data accurately, it's not possible because that data is not available. That final order itself is not available, right? There are missing values such as what was the date of first hearing, what was the date of last hearing, what is the age of the case. So you're not able to determine these basic parameters because of these missing values. I think you mentioned that you can have drop-down menus, but then if we have drop-down menus, it makes sense in terms of data entry, right? But in terms of researchers, if you're looking for something that is not there in the law, like 66A, it's been struck down. So they're not going to enter that in the drop-down menu as well. So that's going to lead to issues as well, probably, maybe. But okay, coming now to the stated aim of the e-courts data. So they say that it's to automate the processes to provide transparency and accessibility of information to the stakeholders. They talk about enhancing judicial productivity, both quantitatively and qualitatively, and to make the justice delivery system more affordable, accessible, cost-effective, predictable, reliable, and transparent. So so my question to Apurva right now would be, in terms of your research, do you think that the e-code project has been successful in achieving this aim?
I think we're very far, like really very far. Because, I mean, as we are professional researchers, and it took us almost a year and a half to be able to make sense of this data. And that too, when we're just looking at one legislation. How are judges supposed to use this data to take policy decisions? Like, or senior judges who are in a position to use this data to analyze trends, to look at different patterns in the data. But if it's so hard for us who do this professionally, how are we expecting judges to use this?
May I just interact at this point because there are some very important takeaways from this presentation, especially from the perspective of the overall objective of this interaction at RGNUN. First of all, I guess the micro issues that you are pointing out in the trains, they are definitely there. But I think let us also probably take up this matter in this sense that there is a user perspective and there is a maker's perspective. These data have been, the data has been created from the maker's perspective. They have probably not looked at the user's perspective, and we are the users. Users may have different kinds of issues because you have certain ideas, but the makers didn't have. So this users and makers gap in the data should be one of the important recommendations from our side. We can discuss with the data creators and makers that if the end objective is what you are saying at all, if they want to study the pattern and come out with certain prescriptions. But to me, at times, the state's aim largely remains to use this data as an administrative requirement rather than any research-centric idea or the objective or the end. So we need to emphasize this point that apart from the like Supreme Court annual report, it's administrative. Lok Sabha, Raj Sabha, Parliament, they are administrative because under their different acts, they are supposed to create their annual report to be filed and to be submitted to the government. So to that extent, this is the maker's perspective. We are criticizing the data as users. Users will always have problem because we are very ambitious about this data.
Their own aim is very ambitious.
Yeah, their own aim is also ambitious. But probably while making this data, these things are very important. Like I remember NCRV's experience because I've been associated with VPRND for a long, long time when the data was with VPRND. So BPRD said we had to just collect the data and submit. But the users started. So Maya is very right that we should come out with our idea so that we could influence the data gathering, data capturing, data compilation process in a manner where we can really make a meaningful research and meaningful contribution to the policy evaluation. So I said there are two issues as far as this study is concerned. One is that there are lots of things which are missing. You have pointed out they should probably supplement it. Secondly, I also find that there is always a problem when we try to derive some uniform inferences from this kind of data. Because the situational and contextual ideas in every state, in every district, in every case. So one POXO case is a one for us, but that POXO case may carry lots of complexity. So one cannot be equated with 10, 5 or 12. One case may be of a very complex, so the time taken in disposal and the age of the case may vary. So I guess some contextual information in terms of data can also be a very great idea to be provided. Then probably the inference drawing will be safe. Otherwise, trends probing, because researchers are probing the trends, it might be, and it might be little difficult because we need to modify the way we derive our inferences from the data. So contextual information of the cases can be one of the parameters to be added in this exercise to make it more meaningful. And I always say that this kind of discussion can provide us the future of criminal justice data. Future of criminal justice data as envisaged by the researchers and users, and impacting the data capturing exercise in terms of supplementing the additional information to be added in it, something going to be very, very important.
The problem is when you're dealing with this larger data set, when you're dealing with the final data set that we arrived at was about 230,000 cases. You cannot possibly go through every single, like out of this, about 110,000 cases were disposed cases. So we cannot humanly go through each and every judgment, and we cannot even use machine, because a lot of these judgments are in regional languages, they are not machine readable, they're just scanned copies. So they actually require you to go through them. But what we've done is we've done this for a sample.
Yes.
We have taken a sample and we've analyzed those judgments and looked at the contextual factors as well. But I haven't presented.
No, your case is perfectly all right. I'm talking there could be a primary research where this kind of work has been carried out. So suppose I have an inference from your study that you said the trend is declining, or XYZ finding you make. If I'm interested to make a deeper probe in that particular finding, emerging from your data or emerging from IJR data, then I should have that problem. So I can focus why Haryana or why Delhi and why a particular district in Delhi. So I should have that information to be able to really qualify saying something on that data, because that observation becomes very crucial. So if I draw a general observation from your data, XYZ, but I want to make a deeper inference from that data, another researcher, another study, because in West, there is a trend of replica study.
Yes.
Replica studies are so replica study indeed they want to verify whether the findings of your study hold true or not. But to be able to do that, you need to have the specific data set, giving some more insights with regard to many other parameters having a bearing on that trend. So I'm talking about that micro details. But for your, like you are doing a data set of 4 lakh, for you, this trend depiction is all right. So this is okay. You cannot do with every case, but I'm talking a researcher who want to do a PhD on a very specific time taken by the prosecution in time taken in cognizance, why 3 years? So whether 3 years, in cases where 3 years are, they are different from the general, which are not taking 3 years. Suppose I have a question. The cases which really end in 1 year or slightly more than that are qualitatively different from those which are taking 3 years. So what are the special situations associated with 3 years disposals cases. So both that is only possible if I have unique. So uniqueness of the data. I always say as a as a basic student of RM, that uniqueness of the data is always there. And there is a generalization effort also. So for generalization, this is already, but to prove the uniqueness of the data emerging from a generalist study can be a great way to look at.
Agreed, sir. And I think that is that leads me to my final point, that I think it makes a lot of sense for us to make our data sets public, so that people can actually use them to do further research. And that is something we're aiming with this as well. At least the clean data sets, we want to make them public so that people can take them forward. We don't want our research to just stop at these general trends. We would like if people, let's say in Namchi, which has a very high incidence, want to look at it and investigate further why is this happening, or even refute some of our claims.
It was indeed a very good presentation. I think just I would like to give some inputs on 2, 3 queries raised. There was one query that why the average time taken in conviction is more than in acquittal in POXO cases. So I think the main reason is hostility. If the victim herself turns hostile, generally the evidence is either a page or so and it ends in acquittal. But if it's a conviction, it is a lengthy cross examination and it takes more time. And then it was pointed out that the maximum time taken in a POXO trial is evidence. So what can be done? So my humble suggestion would be is that either they can be like in CPC we have a provision that we can maximum have 3 adjournments. We can restrict the adjournments here that in POXO trials the cross examination shall be done on the same date the examiner in chief is recorded without any adjournment. And so far as we were talking about data inaccuracy, so I think the only solution is that we can have a separate cadre of data entry operators who are experts dealing in that matter. Because the data entry is done by the court clerks and it is supervised by the reader, who though they have received general training, but they are not experts in that. And there is just one system officer in the entire district comprising of an average of 40, 50 officers and even 80 to 90 officers in a state of UP who has to look after all that. So if we have one system officer every court or one system officer every 2 or 3 courts, I think the data health can improve.
Thank you so much. Those are actually really very
One
useful
more thing.
suggestions.
Just want to add, you have given a very good presentation. So sometimes we are also users of the same data. And just because of that, the wrong feeding of the data, we are also being suffered by that. Once in a high court, we were just taking out the cases of a client, a particular name of the client, and we found that that client has entered his name in varied type, double A, single A, just a name, and he changed the name and slided it off. So this is the basic problem. When we are dealing with the bail applications and bail applications of the same person, how many times he has moved the application. In that cases, so far my suggestion is that data entry should not be lengthy process. It should be stick to the either numbers or the limited options were there. It should not be entry oriented option. Meaning thereby, if you are entering the name, you may give a certain number to that name. And so far as sections are concerned or the case type are concerned, if we are entering the POXO case, then we will make it just criminal trial POXO, criminal trial IPC, criminal trial NDPA. These type of, they may, I think, classify the data more efficiently. So, and thank you.
So just to add, sir, what you have said, and also Saxena, sir, what he has added. I think the time has come where, we are just not looking at the trial and the law, because there would be some sensitive areas, like as sir said, that there could be a contextual referencing of the case too. So probably within subject matters like POXO or probably Juvenile Justice Act, where we are having too much of sensitivity towards, the holistic timeline that has been involved in. probably we'll have to go down to that level where we are categorizing also the borderline cases. I mean, for last few years, we are seeing that something like, if JJ Act, if I may refer, I think Barun Chandra Thakur versus Master Bholu, that case that had happened, the decision where, even though the child who was involved in the act, because even though below 18 still has been prosecuted regularly, Supreme Court said, no, he understands what exactly he has done. So probably those exceptional and borderline cases, we need a particular person who is making a data entry to understand that this is an exceptional phase and that has to be brought down to that level of data. So as Sir rightly said that, it's not just about the subject matter which is involved with the case, but it's also about the exceptional part of it. And then obviously, if you're having too much of categorization within that also, we have to be very, very selective. That's the only addition. Thank you.
Thank you everyone for this interactive session. I invite you all to join us for a cup of tea outside, and we'll get back and start with the next session at 11 a.m. Thank you.
I welcome all of you to the second session for the day. The topic for discussion is quantifying barriers to access to justice. And for this session, we have amongst us Mr. Sunil Chauhan, who is a former director, National Legal Service Authority, and is additional district and sessions judge Haryana. So in this session, the discussants would be I myself, Dr. Shruti Goyal, and I would be accompanied by Dr. Abhinandan Basi. So I welcome you to the second session. So please, if you would like to briefly introduce yourself.
You have introduced. I'm thankful to you. That is my introduction. Very good morning to one and all. And it's an honor to be part of this conference, the overarching aim of which is to promote data-driven policies. So in this presentation, I will be covering, or rather briefly touching, barriers to access to justice, role of legal services authorities, relevance of assessing barriers to access to justice, tools for assessing access to justice, and the ultimate aim, that is how to frame evidence-based legal services programs. Let me enlarge upon the first point, just to give an indication, very rough indication. If we see the total population of this country, it is 1.3 billion. The total cases pending in the district courts at a given point of time are 41 million. You just take out the percentage. This indicates roughly that only 3% of the population is before the formal or conventional justice system. Major part of the population is not before the formal justice system. There may be many reasons. People may be opting for informal modes, or they may not be opting at all. There may be inaction on their part. But certainly it gives an indication that there are certain barriers to access to justice. In this slide, if you see the bifurcation of the civil cases and the criminal cases, this also reflects in rather in a telling manner that people are not opting for the formal justice system. And if you see the report of the United Nations Commission on Legal Empowerment of the Poor, it also indicates that 4 billion people live outside the protection of law across the world. Similarly, other reports also indicate in this regard. And since we are living in a law-thick world where law is touching every aspect of life, so why is it so that only a very small percentage comes to the courts, and what restrain the major part of the population from approaching the justice delivery system? So it essentially, inference can be drawn that there are certain barriers to access to justice. Major barriers are poverty, legal illiteracy, complex judicial processes, geographical barriers, lack of presence of lawyers in the villages and far-flung area, and there may be other barriers. Maybe people perceive that they won't find any solution. But these barriers to access to justice, they vary from place to place. The nature and the level. The nature and the level of the barriers to access to justice, it varies from place to place and from time to time. And different segments of population have different level of barriers. So there may be cultural barriers even. So legal services authorities, what legal services authorities are doing, they are devising programs, they are implementing legal services programs to break these barriers. How? The barrier of poverty by providing free legal aid, barrier of legal illiteracy by spreading legal awareness, and enhancing the capacities of people so that they know law and they also know how to use law. Barrier of complex judicial processes by promoting ADR mechanisms like Lok Adalat and mediation. And the barrier of geographical barriers and this lack of presence of lawyers in far-flung area by reaching out to the people through various modes, like opening of legal services clinics in the villages to cater to the legal needs of the people. Now the question comes, before that so keeping in view these barriers, the various activities which legal services authorities are doing, those activities can be categorized into 4 parts. Primarily the first 3, Legal aid and assistance. This pertains to the court-based legal services in which the legal representation is given, legal assistance and legal advice is given, particularly in the court-based matters. Secondly, outreach programs, which consist of legal awareness programs, legal empowerment camps also, and reaching out through other modes, Lok Adalat and mediation. Now comes the question that why arises the need to quantify these barriers? Because in legal services, if you see the organogram of legal services authorities, at the national legal services authorities have presence across the country, at the state level, at the national level, at the state level, at the district level, and at the taluka level. So at the national level also, the legal services programs are devised, at the state level also, at the district level also. So we have limited resources, keeping in view the geographical area of the country and keeping in view the population of the country. The human resources primarily consist of panel lawyers and PLVs. PLVs are around 44,000 and similar is the number of panel lawyers. And finance resources are limited. So how to prioritize the things? How to prioritize that where we have to invest how much resources? And secondly, how to devise legal aid programs in accordance with the local needs. Because if there is a demand for product A and we supply product B, it will be a futile exercise or rather wastage of human and financial resources. That is the reason that we need to quantify barriers to access to justice. For instance, as I mentioned earlier, that there's a lot of diversity in our country. If you see the topography or the demography, you will find a lot of diversity. For example, let's compare two states, Nagaland and Uttar Pradesh. If you see the number of inmates in the jails, Nagaland there are 692, and in Uttar Pradesh there are 1,21,000, around 1,21,000. So obviously we will be opening more jail legal services clinic in Uttar Pradesh, and the frequency of the visits of the lawyers to the clinics will be more in Uttar Pradesh. And if you see the number of villages in Uttar Pradesh are in lakhs, but in Nagaland are in thousands only. So the number of legal services clinics may be more in Uttar Pradesh than in Nagaland, but keeping in view the density and the topography of Nagaland, one legal services clinic may be serving only a cluster of 2 to 3 villages, keeping in the topography. But in UP, one legal services clinic may be serving a cluster of 10 to 15 villages. So what I'm trying to say is this, that because of diversity, we have to have different approaches. So that's why we need to study the data and to apply other tools for taking insights of the local scenario. Now, what are the tools which we normally use? Legal needs surveys, administrative data of the legal aid authorities, which is generated through various units like front offices, legal services clinics, and which is also gathered through campaigns, legal aid campaigns, legal awareness camps also. We utilize those camps also to gain insights. And official data like Census of India, even NCRB data, we utilize those data also to make informed for informed policy making. Now, as far as these tools are concerned, these tools complement each other. It's not like that legal needs survey will provide the entire thing, because all the tools have certain advantages and all the tools have certain limitations. For instance, I'll just try to indicate that how the official and administrative data indicates and how it is to be supplemented by legal aid service. If you see this slide mentions the number of inmates admitted during 2020 in the prisons. This is on the basis of the official data, NCRB. And the number of total arrestees who were released on bail in the first instance. So what does it indicate? That 76% of the arrested persons, they were released at the first instance. So this gives an indication, or this, gives some clue that we need little bit further, we need to probe that why such many, since many arrests are taking place and these prisoners are being, arrestees are being released at the first instance. So there is a possibility that unnecessary arrests are taking place. Or maybe the people are not getting legal assistance at the pre-arrest stage, or they may not be getting assistance when they are arrested in the police station. So when we analyze this data of 2018, 17, and 19, we got the similar patterns. Number of arrestees are more, and number of persons who are admitted in the prisons, they are less. So combined with the other data and other tools, we devised NALSA's policy for providing legal assistance to early stages, at early stages of criminal justice, that is at pre-arrest, arrest, and remand stage. So this official data gives you an indication if you study the patterns. Similarly, when we analyze the data of women inmates, we found that 5 states have 56% of the women inmates at a given point of time, and 40% of the women inmates are in rest of the states. But this official data is not indicating that what is the reason. Are they not getting any assistance in Uttar Pradesh, Madhya Pradesh, West Bengal, or are not they willing? Are they not aware of their legal rights or legal remedies like bail or filing of appeal? So this gives us a clue that where we have to focus our resources and where we have to focus our research. So this is the benefit of official data. Now we have to combine what we do. We combine this our administrative data, which is generated by the legal aid authorities, with the official data to draw more inferences. Like if you see this slide, we have number of legal services clinics. By taking the official data and the administrative data and analyzing both the data, we found that the number of beneficiaries per lakh population in different states vary. For instance, if you see the state of Uttar Pradesh, there are 16 beneficiaries per lakh population. But in Jharkhand, the beneficiaries are 1421. The population of Uttar Pradesh is around 241 million, but the population of Jharkhand is only 30 million. But the beneficiaries are more in Jharkhand as compared to Uttar Pradesh. But this is not giving us the reasons that why it is so. This is just pointing out the weak area where we need to focus. So we need to have legal surveys that what is the problem that in Uttar Pradesh we are only having 16 beneficiaries per lakh population. There may be many reasons. People may not be aware of the legal services clinics, or they may not be aware, or they may be having a perception that legal services clinics are not effective. They do not provide solutions. So official and administrative data gives us a clue that where we require to focus our research and resources, but to have more inputs and insights, we have to combine this data with the legal needs surveys. So that's why I say that all the tools, they complement each other. Similarly, when we saw the number of cases pending in the courts and compared it with the number of legal aid cases at a given point of time, we found that the legal aid cases are very few, almost negligible in some of the states. So that gave us a clue to formulate some new model of legal aid, particularly in court-based services. So when we combined it with other research tools, then we came up with the model of legal aid defense counsel system. which was launched in 2019 and which has recently been expanded to other states in incremental manner. These two slides also indicate the inferences which can be drawn from studying administrative data with the official data. Now, what is the difference actually? Administrative data gives a general overview. It is good for general assessment, but it cannot provide the policymakers with the information necessary to assess the true scope of the needs. What are the unmet needs? Why the needs are unmet? What is the problem resolution behavior of the people? And what is the problem clustering? Is problem clustering taking place or not? But legal needs surveys, they do provide all these things, and they go beyond the government and administrative data to provide a multidimensional picture of the ways in which access to justice can be secured. But legal needs surveys, one conducted, you can't conduct the surveys time and again. Frequency, the data, the inferences drawn from legal needs surveys, they are not updated quite frequently, one thing. And moreover, legal needs surveys are time consuming and cost factor is also there. So it has to be read with administrative data. What I have seen that on the basis of legal needs surveys, if you finalize the formats or if you data collection formats are improved so that the data is collected at various units with sufficient granularity, then I think that updating gap is fulfilled by the administrative data. So why we need legal needs survey? Because legal needs survey gives perspective from the point of people who face them. Interaction is made with the people. We come to know that what sort of legal issues are being faced by them and what approach they are taking for resolution of their disputes. And what is the impact of those legal issues on their lives. For instance, I have taken this data from one report prepared by Daksh, carried out by Daksh, a very excellent research they carried out. The number of respondents were around 50,000. So if you see the point number 2, 3, and 4, why people are not going to the courts, they have found that cost of litigation is too high. Third is that they do not know how to file a case, how to navigate the system. Or third reason is cases take too long. So we can identify the particular areas. For instance, if 26% of the persons are saying that they do not avail the legal remedy because cost is high. So it is quite probable, quite possible that they are not aware of the availability of free legal aid. Or they may be having the perception that the quality of legal aid is poor. So this legal aid surveys gives us very clear indications about the reasons so that we tailor our policies accordingly. For instance, the legal need, I've taken a snapshot from the justice needs surveys conducted in Bangladesh and Netherlands. If you see, the justice needs survey can give you an indication in quantitative form that how many people are opting for formal justice system, how many people are opting for other modes of resolution, and why. But the limitation of legal needs surveys is this, that generalizations are made on the basis of small samples. For a country like India, where the population is 1.3 billion, if you take the sample of 2,000 or 50,000 and generalize the say for the entire nation, it may not be applicable for small geographical portions or for different segments of population. So the legal needs survey may not be useful when it comes to intervention for particular segment of population if the representative survey is not including that segment of population, and it may not be relevant for small geographical areas. So that is why, as I said earlier, that we have to we have to fill up that gap through our administrative data, because our front offices and other units like legal services clinics, they are operating at the ground level in small geographical portions and maybe for particular and targeted population. We conducted one campaign for women prisoners in 2019. Now, what we do, we have not conducted any exclusive or independent legal needs survey, but there is a method which we have developed. When we devise the campaigns, we form the teams. We give them the questionnaire, and also we train them that what is to be done and how it is to be done. So in campaigns, two purposes are solved. One, legal needs are identified and legal assistance is accordingly provided. And secondly, that also gives us an opportunity to do survey, because we are interacting with the people having legal issues, or we may be interacting with people who are not having legal issues. So that campaign part, we embed that survey part into the campaigns to make it more economical and to get updated data, and at the same time to understand the problem and provide the solution there only. So likewise, we conducted a campaign for women prisoners. At a given point of time, total inmates across the country are around 16,000. So we interacted almost with 90% of the women prisons across the country. So the one conclusion which we derived, that non-legal problems and legal problems can't be seen in isolation. Legal problems, they do trigger non-legal problems, and the non-legal problems also trigger legal problems. For instance, we found that the women inmates who were suffering from mental illness, it was primarily because of the reason of the legal issues they were facing. So certain other insights were gathered. For instance, many women were not aware of their right to appeal. So we identified them and provided them the legal lawyers, but at the same time, it gave us insight that we need to have more awareness campaigns in the women barracks also. And we have to change the location of jail legal services clinic also, so that it is accessible to women inmates. So this is the strategy which we follow, embedding the survey part in the campaigns and to take insights, understand the problem and provide the solution. So if we see the service across the country, across the world, what these legal services surveys have found, that justiciable problems are ubiquitous because law is everywhere, like oxygen, present everywhere. And justice problems are linked with disadvantage. The marginalized people, the people who are living, who are weaker section, they are unable to manage their legal problems. And it has substantial impact on the lives of people, those facing them. This we got even in our women prisoners campaign. And phenomena of problem clustering is there. This is very important actually. This is very necessary to understand. If one legal problem can trigger other legal problem, so it is better to identify those problems so that we do interventions at the initial stages rather than at the stage when those problems turn into full crisis. So that is the reason that in front office and in legal services clinics, what we did, we standardized the formats of collection of data. Because a lot of people come, so we have now started to understand that what is the nature of the problem, and whether problem clustering is taking place or not. So the trend can be for various locations, areas we can point out that these are the legal issues where the problem clustering can take place. So we can have other interventions through like organizing more local adalat or opening mediation chambers or starting mediation in the legal services clinic itself. Across the world, the legal services legal service have indicated that people seek help from a wide range of sources, choices often informed by relatives, friends, and colleagues. And very few people resort to formal legal system. They take the help of lawyers only in very severe legal issues. So in conclusion, legal needs service have demonstrated that different population groups have different attitudes to problem resolution. They face different obstacles and have different needs in relation to the help and processes available. A change of approach is also noticeable as far as legal needs service are concerned. Now the legal needs service also try to assess the legal capability, try to understand the problem resolving behavior and the impact of legal issues. Now the lessons which we have learned is, as I said earlier, all the tools complement each other. Outreach campaigns for targeted populations can be utilized to estimate the legal needs of a particular segment and study related aspects. And the basic units such as front office and legal services clinics can capture data to indicate the nature and extent of legal needs. So we have to improve our data collection techniques at this basic units which are working at the ground level. And during Lok Adalat also now we have found that when Lok Adalat takes place, we can capture the experience of the people whose cases are taken up in the Lok Adalat, because we will be able to improve the Lok Adalat system only by taking the inputs from those who are facing the disputes. And administrative data should be made accessible to all, because if it is made accessible, the civil NGOs and other research bodies can do research, and that also provides us good insights. And engagement of experts is the requisite actually. What we have seen when we formulate the questionnaires and the formats ourselves, those formats and questionnaires have very less granularity. But when we engage the experts who are the domain experts, the quality of the questionnaire enhances. So for evidence-based programs, we are using this technique, gathering evidence and needs analysis, then identify the targeted population, formulate the strategy, implement the legal aid program, monitoring and evaluation. This is, the snapshot of the strategy which we normally follow to have evidence-based programs. For instance, if you intend to intervene in a particular district, each district consists of different tehsils, different topographical diversity and demographical diversity is also there. So you can make the variables like this: people with disabilities, drivers, laborers, victims of crime. For instance, a district A may be having persons suffering from disabilities in only 3 tehsils out of 10 tehsils. So we have to divert our resources for those 3 districts when it comes to campaign with the persons suffering from disabilities. And apart from that, if we have this data, we arrange this data like in this format, it helps us to formulate the strategy matrix also. For instance, if we start the campaign of right to education. Then the number of villages which we have to cover, which we can take from the previous, the data bank. The targeted population action activities needed, the tools which we will be using. And at the end, we can also, just to measure the outcomes, to have measurable outcomes, to see the impact of those campaigns, we frame the indicators. So this is our approach to evidence-based policy making. Thank you.
If you allow, maybe please, some.
Please.
Thank you. So we've just spoken about formal and informal justice system in India, and when we talk about Nalsa or Lok Adalats, we've pushed, we are pushing rather towards, a system where Lok Adalats are becoming very important, where informal systems are becoming important. How far do you think mediation and Lok Adalat can serve the purpose? Because if you look at the data later on, because if you look at Daksh also, the data that they've collected, we still do not believe in them, sir. We've created new laws, we've created such a stringent system of, applicable procedures. How do we improve them? How do we improvise them? What is the level actually of the actual implementation that we need to push it towards, like mediation, negotiation, Lok Adalats?
Actually, if you see Lok Adalat, we have two models of Lok Adalat in India. First is the normal Lok Adalat, which is organized under Chapter 6 of the Legal Services Authority. And apart from that, we have permanent Lok Adalat for public utility services in Chapter 6A. So the first model of legal Lok Adalat, it can pass the awards only on the basis of settlement. But the second model, when it was realized that certain cases are so, they are not major disputes, very petty disputes. So if both the parties do not agree, they will go to the courts. So this another model, that is PLA-PUS, was devised. So it can decide the cases on the basis of settlement. If the settlement does not take place, then it can pass award on merits. So what I intend to say is this, that we have been learning from our experience and we have been improving the mechanism of Lok Adalat, one thing. And secondly, the most important feature of Lok Adalat is if you go to the areas which are geographically isolated areas, if you have to settle dispute through Lok Adalat there, Lok Adalat is available there. But you won't find arbitration or mediation also, mediation there. Because mediation is growing, but still we have a long way to go to reach out to the rural areas. So as far as other informal systems are concerned, we also need to understand those systems also. Actually, there is no, I've not come across any study about the mapping, about the informal systems which are existing in our country. So actually keeping in view the fact that most of the cases can be settled at the pre-litigation level, one thing. And the fact that these methods are cost-free methods, I think it can go a long way in promoting access to justice. So this is my view.
My question is that you talked about the legal aid defense counsel system that Chief Justice Lalit, he again said. And there he said that 70% of the population is below poverty line, whereas only 12% of the population is opting for legal aid. Do we have any study which maps the reason that why even people below poverty line, they are not opting for legal aid?
Actually, when it comes to legal defense counsel, let me tell that there are three models of legal aid across the world. One is counsel assignment system, where we have the panel of lawyers who can take private cases and they are paid on case-to-case basis. But legal aid defense counsel model is on the lines of the public defender system, where we hire the lawyers, we pay them monthly salaries, but they cannot take private cases. They only their work is confined to legal aid cases. And the third model is contract system, where the contract is made with the legal firms or lawyers to deal with particular type of cases. Now, as far as percentage of the people who are eligible for legal aid, that is quite high in India. Almost 80% of the population is eligible for a reason. When you see Section 12 of the Legal Services Authorities Act, the means test is not applied to most of the categories. That is one of the things which you won't find in across the world. That's why I say that Indian legal aid system is quite unique when it comes to that. But why, if 80% of the population is eligible for legal services, and while less percentage is approaching, then you have to see that thing from, you have to take the entire picture, you have to examine the entire picture. When it is said that very few people are approaching, then that is vis-a-vis the court legal services. That is not vis-a-vis the outreach programs which we are doing, or the Lok Adalat which we are implementing. So as far as court-based services are concerned, there are various reasons, and one of the reasons which emerged in one of the researches conducted by one professor from Delhi, that people have poor perception about the quality of legal aid. They feel that we are delivering poor legal services to poor people, and that is the reason. That's why I'm saying that we get insights from these researches. That is the system that we have devised new model of legal aid, that is legal defense counsel system vis-a-vis code-based services. I hope that it will increase the quality.
Face and you've just spoken about the retainers. The basic problem that we face when we look at legal aid, or when we are doing, we're proposing the, alternatives to people who approach us for consultancy or for any other advice that is coming to us. The issue is that there is no one conclusive system to look at the performance of the retainers.
Retainer lawyers.
Yes, sir.
Oh.
So when we look at the retaining lawyers, because I think the basic drawback that we face is that there is no follow-up. And that also leads to increase of pendency of cases, sir, because when you look at the utility cases that are being filed in permanent local adults also, there is a pendency of cases. There's again that issue of a drawback of it stretching beyond the limit that it should have followed is again an issue. How do we create, within this legal system, a check and a balance approach for the retainers, sir? How do we do that?
Actually, now what is happening, that technological tools are also being devised to have better monitoring, and monitoring indicators are also being devised to monitor and evaluate the performance of various this thing of our different legal aid programs at various stages. You are right that there was some issues with regard to the delivery of services through retainer advocates. And that is the reason, if you see the newly devised front office guidelines, that's why those front office guidelines were framed one thing. If you see annexure to those guidelines, it contains the format for collecting information. So I think the steps are we have been taking steps, and I hope that in the long run, those steps will enhance the quality of our legal services. Actually, if you see the monitoring and mentoring guidelines of NALSA, monitoring guidelines are confined to monitoring of code-based services. So outcome of a case does not determine whether the lawyer has delivered the quality service or not. That cannot be the sole indicator. So that is the reason that apart from we have derived indicators from the processes. If a case is assigned to an advocate, how much time he took to have interview with the legal aid seeker, whether he updated legal aid seeker during the course of the case, whether he visited the crime scene where required, and how he did the cross-examination. So we have called out various indicators, keeping in view the entire the concept of quality from its holistic sense. Actually, what we have seen, although we have devised the monitoring guidelines, but collection of data is a challenge, and it is improving very gradually actually. That's why we are unable to implement it in a effective manner.
So we open the house for discussion.
So one thing, there is a docket explosion in every field. Even if we say of Lok Adalat, or we conduct arbitration, or we conduct conciliation, or we conduct the cases, we basically invite the cases for being decided in the Lok Adalat. Lakhs of cases are being listed. Basic problem is that we have limited infrastructure, limited manpower to give notices to the persons. Even if we are also engaging the services of email and WhatsApp for giving the notices to the parties, and until unless the parties appear and in the Lok Adalat won't be successful. Along with these services of Lok Adalat or whatever it is, alternative dispute redressal, we have to manage side by side the ancillary process as well. So for that ancillary process, we require certain manpower, we require certain finances to deal with. Otherwise, we won't be able to do that. And that's why presently what we are doing, we are at the nascent stage of all these things, alternative dispute redressal. And just because of that, we are just improving our services. We are opening the doors for these alternative dispute redressal. And we are inviting the persons to come. But it is still not a developed set. That's why this is the basic practical problem. Along with the disposal, along with any other pendency, we have to look at the ground level problems, and we have to address those problems as well. So far as this defense legal service system is concerned, complete new system added, just added. We are already making an infrastructure for that, and very soon we are going to open this. And I probably say that Noida is the main hub of that. We are just preparing the infrastructure. But so far as the infrastructure is concerned, we are having a good building. That's why we have taken out our room, prepared a cabin for the Defense Legal Services Council. But the basic problem is where to purchase the chairs, tables, where they will sit, from where we will take out the finances. These ancillary processes, if go side by side with these policy making, then it will fetch more good results.
Rightly said.
Thank you.
I had a quick question. So you spoke about the fact that particularly with women inmates, you found in the surveys that NALSA did a lot of problems that were non-legal and that were also creating certain barriers for them in accessing legal aid services and accessing ultimately justice. And I was just wondering if there was any conversation in NALSA about increasing or either expanding the idea of legal aid to include a cadre of social workers as well. Because our experience in Pune and Nagpur has been when we work with under trial prisoners that often when social workers are meeting the prisoners, they are very often being able to solve a lot of the problems that are initial barriers for the prisoners to access justice, even on issues like um, where's the house, where's my family, in trying to find those sorts of basic information. So yeah, so I just wanted to understand if either earlier or now with the legal defense system that has been set up, the pilot trial that is going on, if there is any conversation or you see the need for social workers and non-legal people who might contribute to the field and broaden the idea of access to justice.
Actually, you intend to say that we need to have some collaborative approach, legal services authorities with the other entities who are working at the ground level. And so, actually what happened, if you see the framework of that campaign, we constituted teams. The team consisted of panel lawyers, team consisted of social worker, team consisted of psychiatrists, and team also consisted of voluntary organizations, other voluntary organizations who were working in the jails. So that was a very, very good collaborative approach. That's why we came to know that the non-legal problems have some connection with the legal problems also. And certainly you are right that to have collaborative approach, we need to engage more social workers. I think that is being done, but not in a very structured manner actually.
Sir, I had a query that we already have a system of having panel advocates. So how is the Legal Aid Defense Council system different from that?
Actually, as I said earlier, that there are three models of legal aid. One is counsel assignment system, which we have been following since the enforcement of legal services authorities. What is counsel assignment system? That we have panel of lawyers. They can take their private cases and they are paid on case-to-case basis. We do not then pay them the monthly salaries. Legal aid defense counsel is a system where we engage lawyers. We do not pay them on case-to-case basis. We pay them monthly salary and they cannot take their private cases. They have to deal only with the legal aid cases. The idea is to enhance the quality. What we have seen that the private lawyers sometimes give more importance and more focus on the private cases instead of legal aid cases. So this is the basic difference between both the systems. And moreover, legal aid defense counsel system is confined to criminal side only. And panel lawyers we can utilize as per their expertise in civil. It started functioning in in 2019 and 20 we opened legal aid defense counsel offices in 10 districts. In 2021 we added 3 more, so now 13. So that was those districts were selected for pilot study of this system to make course corrections and to further implement it in incremental manner. Pilot project actually we visited, for instance, I also submitted 2 reports of Bharatpur and Chaibasa. What I found that those legal systems, those legal defense counsel offices were providing quality legal services. And that was the reason in Chaibasa, we were having out of total session trials in the Chaibasa courts, the legal aid cases jumped to 28%. Out of those total cases, 28% cases were being dealt by the legal aid defense counsel office. At present, I cannot say much because maybe a lot of information is made accessible by NALSA, but at present I cannot say because I'm not in NALSA.
Sir, you mentioned that you found in the survey that a lot of women had mental illnesses that for which the legal problems were the main cause. How did you arrive at this conclusion?
Actually, we had in our team psychiatrists. panel lawyers are not capable enough to, diagnose the mental illness. Because the experts were there, that's why we were able to identify the same. That was the reason.
I have a question. We also visited the Bharatpur facility and found it to be, deeply committed to their work and all. You couldn't fault them on that. There's two things quite disparate that I want to ask about. One of the things I felt was that, like you said, sir, you had the infrastructure and you had the people there, and it became an office. It became a kind of one of the official, a place of officialdom. And yet the people that have to access these people are extremely poor, don't know their legal rights or anything. So I felt that the whole setup, being as it was in that complex, was also born almost inaccessible unless you know, unless there has been a tremendously big outreach program into the villages around, into the district around, that says, should you have any problem, you are very welcome here, or we will come out to you, because the cost of coming to that council is also something. And so I did in fact suggest that that there needs to be some, you can't ask these lawyers to go out also and publicize themselves. So there has to be a methodology of publicizing that this facility actually exists. And in that, I did not find that the whole judicial mechanism was assisting with this. That was one comment that I had. The other thing was, I was looking at the statistics for that area and asking the legal aid authority there, and they told me that, and Valet will have to tell me if I'm saying this correct, that there had been 1,000, was it 1,000 camps or legal awareness initiatives in that year, which was also a COVID year. Now, I found that difficult to accept. I didn't want to question them because obviously they thought that this was so. But how did one check that? 1,000 camps? That would be 3 camps a day.
Actually, there is a difference between legal awareness programs and legal empowerment camps. Legal awareness programs, what we do, our resource persons go to the villages, people also come there, they are made aware of certain rights and entitlements. They are also made aware of about the availability of free legal aid. But as far as legal empowerment camps are concerned, it consists of doing survey before the camp, identifying the people who are being deprived of their entitlements, and then assisting them in connecting to the relevant authorities. And on a particular day, a camp is organized where all the government departments put up their stalls, and the legal aid authority also puts up the stall, and the benefits are delivered on the spot. So the mechanism is different. Maybe you have captured the data of legal awareness program instead of legal empowerment camps, or this I'm saying that obviously data cleaning is something, data validation is something which need to be strengthened.
You divide it or whether you aggregate it, it's still 1,000 camps
Difficult to digest.
in 15 months.
Should I say something?
Please.
So far as legal awareness camps are concerned, various persons, various groups used to go on various directions. That's why 1,000 is not a bad figure.
It's not a bad figure, it's just not believable.
It is believable because many groups have been created. Not only one person goes many places, but group of persons goes to many places, and that's why.
And the
As
part,
so far as Defense Legal Service concerned, it is about the pending cases. Those persons who are coming to the court, they have been diverted. If they won't be able to get their counsel, then they will be diverted to the Defense Legal Services office, which is created in the complex itself. So those persons are already coming to the court, and they have been directed to them.
Sir, we totally respect that, but the fact is during COVID, the courses are also online, sir. Sir, am I allowed to ask a very utopian question? Would it be like, would the House participate in that? The idea here is that we've spoken about the data, which says that what are the hindrances that we are facing, even if we are looking at a small population of sample, still respectable, opinionated, and it makes a difference. It tells us that what are we looking at? What are the hindrances that we are looking at? Sir just spoke about an informal system and a formal system, which is still in clash. We've spoken about a fact that yes, the psychoanalytical help is also required. We need to analyze different situations because somehow we've conveniently forgotten that few inmates would not want to go out of the jail also. They might not, they might skip legal aid or looking for legal aid because they don't want to go out. And it's convenient. And specifically during COVID, we've witnessed it, that nobody wanted to go out because food is available or other things are available, or maybe social taboo says that the women are not going to be acceptable. I'm referring to, I wish to understand that are we looking at the system of NALSA and legal aid? Can we devise, or are we looking at a very strict system? Because when sir pointed out at the difficulties that we are facing, imagine an institute like NALSA facing difficulty for money. What are legal aid clinics at schools going to do? We've just had an example of Bharatpur. We've had example of smaller districts. What are we looking at? One. Two, if we are looking at systems like permanent lok adalats, mediation camps, we have these psychoanalytical help groups and psychiatric help groups when the family matters are also being consulted for legal aid clinics. And the family matters are referred to the mediation cell. People do not turn up. Even if they're summoned, they do not come. And then till the time the other party is going to approach us or it is not going to come, that lady who's in need for the redressal for victimization or domestic abuse or anything for that matter, including court holidays. There's no one available during court holidays. Are we like, should we envisage something which is very strict? Would it be possible to bring back the faith of people if we're looking at something which is accountable, sir, which is strict? This is the last question, but this is I asked, this is a utopian, but we need to work on that. So last 2 minutes, sir. I just wish to understand how comfortable are we with that idea, because we need to work on that. If you think it is advisable, then we'll work on it.
Ma'am, just to like figure it out in the same sense, primarily I believe that the whole problem, especially in case of lok adalats, is that the clients go to the lawyer. And the first thing what lawyer, if at all there is a discussion on lok adalats with lawyer, the first thing what lawyer is going to tell the client is, you don't have a chance of appeal, so please don't go there. Gone. I mean, the major chunk just runs away from there. So if I say holiday, no holiday, doesn't make a difference. The first fear, or rather the first injection of fear that has been given by the lawyer to the client is, don't go there. Yeah. So see, then again, this is the same problem. Like first, this hurdle comes. Second hurdle is, even if the client wants to go there, primarily he will say, I'm left for nowhere. Like, I'm not getting any assistance. Secondly, even if I get an assistance from some authority, like as sir has mentioned, what might happen is that they are not very sure that who will defend my case and with what kind of qualitative presence. So that that dicey situation, actually when we are talking about the data, we have to also take into consideration that scenario also, that how many people would opt out of lok adalat in such circumstances. That's another thing which I think is very, yeah. And there are also some initiatives which we can think of. Like, for example, there have been instances where some of the villages have been taken in adoption by certain law schools, and they have been, trying to do that. So those kind of things could help out. But then again, it should not be like, again, the bar would always say that, no, it's going against our interests. So definitely there would be a, crossing of lines probably.
think also that the problem is at multiple levels and of multiple kinds. I don't think there is one solution necessarily available, but I do agree about what you were saying about the fact that one of the things that we found in our fair trial program in Pune and Nagpur was that the more follow-ups you do with the inmates and the more they see you regularly, the more they trust you. So when we were, and this is a program we did with the district legal services because we didn't want to create a parallel system. And what we found was that when the lawyers were visiting regularly, it was the same set of lawyers, it was the same set of social workers. People started feeling like this is a system they can trust and this is a system that will deliver. And so the even the intake, which is that the people who were opting in for legal aid increased massively after a year or so because they were just seeing us all the time over there and seeing us deliver and doing whatever they needed done, including getting bail or finding somebody's Aadhaar card number or something like that. But I don't think there is one problem. I think the diagnosis of each area, each system in that sense needs to be done very, at a very granular level to understand how deep and both deep and wide the problem is.
Thank you, everyone. We'll begin with the next session in next 2 minutes, please. Dr. Datta, am I audible to you?
Yes, I can hear you. Hi, good morning.
Thank you, sir. We'll just begin in next 2 minutes.
Yeah, thank you.
Good afternoon, everyone. Good afternoon, everyone. If I may please have your attention, we are about to begin with the next session. This session is on narrative by numbers, police adequacy, performance and perceptions. Presenter will be Ms. Radhika Jha, Research Executive, Common Cause, and discussants are Dr. Papul Datta Prasad and Dr. K.P. Singh. Ma'am, please.
Good afternoon, everyone. And thank you for, I wanted to thank the organizers for bringing in people from across the spectrum and having this dialogue. And it's been a very interesting day and a half. One thing that I did notice during our discussions yesterday and today was that our concerns about the rule of law in India were to a great extent limited to our concerns about the levels of crime or the sense of safety that citizens feel. However, when we were doing the study on policing in India, the more we studied policing, the more we came to realize that the story of policing in India is a story of discrimination. It is a story of, exclusion and selective targeting. It's about how the police works for the upper caste, upper class, powerful, rich groups to ensure their safety, their hegemony, and reinforcing the existing structures which benefit a certain group. And this is to a large extent what I'll be showing in my presentation of the researches that we've been doing for the last several years. We have, so we've been. All right. Okay. Yeah. So these are the reports that we brought out in the last few years. Some of the reports, we've also brought out some smaller reports. We call the series the Status of Policing in India report. And in all of the 4 reports, we've looked at different aspects of policing. We try to focus on both the analysis of official data, the data that comes from the NCRB, the BPRD, and other government sources, and do a time series analysis of that data. And also, we do surveys. Another large part of the report is based on surveys with key stakeholders. And these so far have been the general public and the police personnel. So like I said, this is a series of baseline studies. And the first report was on the general public's perception of the police, what the people think about the police, what experiences they've had with the police. The second report, which came out in 2019, was on the structures and the adequacy of the police. And we surveyed police personnel across 21 major Indian states and took in their experiences, their perceptions, their attitudes, and their attitudes also towards certain legal procedures. In the last year, we actually brought out 2 reports. One was on policing in conflict-affected regions, because we felt that in the previous reports, we had missed out on a lot of nuances that pertain to certain either left-wing extremist affected areas or insurgency affected areas, especially the AFSPA states. And the other part of the report was on policing during the COVID, the lockdown and the pandemic. In our surveys, we try to make the sample as representative as possible. So we use randomized survey samples using the electoral rolls, and the Center for Study of Developing Societies, which has been doing election studies for several decades now. They are the ones who do the survey, who conduct the survey. And it is most often at as far as possible, we try to make it nationally representative as well. The sample is geographically spread out. We cover a large number of states, 22 states in one study, 21 in another, for instance. Our sample sizes are also, we ensure that they are representative of that location. So we have, for each of these studies, our sizes have been at least 10,000 per study. And these are representative for each location across the lines of caste, gender, tribe, religion, etc. It in a randomized sample, very often the representation matches up without the need for any kind of booster or surveys. But if it does not happen that way, then we also ensure that there's a proportionate representation through booster surveys. And when we survey the police personnel, we try to ensure that the women police personnel are covered to at least to the extent that they are represented in the actual force, and the constabulary and the IPS or the officer level ranks are also being proportionately represented. So let me now come to what the people think about the policing in India. So we found that in terms of police contact, there is actually very little police contact amongst the people. And just about 14% people said that they had had any kind of interaction with the police in the last 4 or 5 years. 82% said that they did not have any contact with the police in the last 4 or 5 years. And this is the general public across 22 states. However, when we disaggregate the data of the people who have been contacted by the police, then we see how the discrimination or the bias or the selective targeting plays out. Because as you can see in that pie chart there, the Adivasis or the Muslims are far more likely to have been contacted by the police than the upper caste, whereas it's not shown here, but the upper castes are far more likely to have contacted the police themselves. Again, the poor are nearly twice as likely to have been contacted by the police than the rich. We also saw that the respondents reported significant levels of fear of the police. 44% people reported that they were fearful of the police in some form. And the largest group which reported the highest levels of fear was the Sikhs, particularly from Punjab. 37% said that they fear the police to a great extent. Within the Hindu community, the upper caste were the least fearful, and the OBCs and the SCs were the most fearful. And the level of fear or what they think about corruption or those kind of factors we realized did not really come into play so far as the level of trust and satisfaction was concerned, because regardless of all of that, the overall level of trust with the police, the level of satisfaction with the police was actually quite high. So 65% people said that they were satisfied with the work of the police. And like Ramachandran sir had mentioned earlier about his study as well, the level of satisfaction actually goes up as your level of contact increases. However, again, if we look at who was dissatisfied with the police and disaggregate that by across caste and religious lines, and we find that STs were far more distrustful of the police than upper caste Hindus. And non-literates were 3 times as distrustful of the police as literates. Now coming to what the police personnel have to say about policing, their perceptions, their attitudes, and their experiences. So first of all, we found that the working conditions of the police personnel continue to be quite abysmal. And the average number of working hours that was reported across 21 states was 14 hours a day. 80% said that they did not have more, 50% said that they did not get any weekly rest at all. And this survey was conducted in 2018. So as of then, only the police personnel from Maharashtra reported to us that they got 1 weekly off day. Since then, a few more states have implemented this policy. And this is very closely related with, the adequacy and the infrastructure of the police. And when we look at the official figure, which is also pointed out in the India Justice Report, the police works at just about 3/4 of its actual capacity, its sanctioned capacity. And in this discussion that we've been having, we've been talking about, the use of technology in justice delivery and AI, etc. But the ground situation in a lot of police stations is actually continues to be quite poor. So we see here that 70 police stations did not have access to even wireless devices. 224 did not have access to telephones. And 24 police stations had access to neither wireless or telephones. 240 police stations did not have access to vehicles. And in states like Assam and Bihar, there was an average of less than 1 computer per police station. So our aspirations are evidently quite different from the ground reality in the police stations. And in terms of the training that the police have been receiving, this is again official data from the BPRD reports. It showed that in an average of 5 years, just 6%, 6.4 actually received in-service training or refresher training. And this 6% is to a large extent restricted to the officer level ranks, whereas the constabulary, which forms about 80% of the police force in India, are much less likely to receive in-service training. When we asked the police about the problems that they faced during the crime investigation, we found that 71% said that the witnesses were unwilling to cooperate, and 65% said that the political pressures were unwilling to cooperate, and so on. In our report, we did not look at the causality of, we didn't look at we didn't verify to what extent this data is true. These are just perceptions as reported by the police personnel themselves. But this points to the need for a more robust system where this can be linked to the level of trust in the judicial system, where the victims or the witnesses themselves are unwilling to continue with the investigation even once they have registered a complaint. We found some very problematic attitudes of the police towards certain vulnerable communities. And for instance, 50%, if we combine those who said that they're very much unnaturally prone, 50% police personnel feel that Muslims are naturally prone to committing crimes. They held similar, it's not given here, but they held similar views about Dalits, about Adivasis. They were very likely to believe that the SC/ST cases were false or motivated, or the domestic violence cases were false or motivated. 1 out of 4 police personnel feel that migrants are very much prone to committing crimes. They were also pretty, their attitudes towards the use of violence and the use of force was also quite disturbing. 1 in 3 police personnel felt that for minor offenses, a small punishment should be handed out by the police rather than a legal trial. And 19% felt that killing dangerous criminals is better than a legal trial, thus sort of justifying encounter killings. 3 out of 4 police personnel felt that it's justified for the police to be violent towards criminals. And 83% felt that there's nothing wrong in the police beating up criminals to extract confessions. So coming to some findings about the policing in conflict-affected regions, we saw that the levels of fear reported in the conflict-affected regions were much higher. And about 1/4 of the people in these regions, in the left-wing extremist affected regions and the insurgency affected regions, reported knowing of someone who was physically tortured by either the police or the paramilitary armed forces. And a similar proportion, 24%, said that they knew of somebody who was being held for Naxalism-related charges, despite being innocent. They also, in general, they also felt that um, uh, the police is likely to incriminate Adivasis or Dalits or the poor rural people to a great extent in false Naxalism or insurgency related charges. So 36% believe that the poor are likely to be falsely implicated, and 24% believe that the Adivasis are likely to be discriminated against. Yeah, so like I said, the levels of fear in left-wing extremist affected regions specifically were quite high. And 40% said that during investigation, the police would favor a rich person against a poor person. 32% said so about, caste discrimination and so on. In our report on policing during the pandemic, we surveyed both the general public as well as the police personnel, and we found here that the overall level of appreciation, and we also did a little bit of a media analysis for the pandemic period, and we saw that in the media, the coverage was that of a very, a very complimentary of the police and very appreciative of the work they were doing, which is true for the general public as well, except that the levels of fear during that period tend to go up, and especially amongst the migrants, amongst the poor sections of the society. And 1 out of 3 common people said that confrontations were quite frequent during the lockdown. 55% people said that they were fearful of the police, which is higher than what we had seen in the previous 2018 survey. And 57% feared fine imposition or being beaten up because of the lockdown norms. Right, and there's a clear class divide here. The poor and are more likely to be more fearful of the police during this period as well. On the other hand, the police also reported that people from the poor localities were the least compliant with the lockdown rules. When we asked the police personnel about their experiences during the lockdown, about half of them admitted to frequently using force against migrant workers traveling back home. And 1 out of 3 police personnel said that they frequently encountered situations where the migrants were trying to enter shelter homes but were prevented from doing so by the police. And this pointed to the limitations of the police personnel themselves in providing the infrastructure and being asked to do certain, management without the availability of resources. So that's it for the findings that we have, that we have got from our report so far. But I did want to point out one more thing before I end the presentation, was that our next study is actually on surveillance and policing in India. We've been talking a little bit about, the use of AI or the use of technology in policing. And yesterday also there was a little mention of those kind of, issues. But as we're doing the study, what we're coming to find out is that it's if there's something that we should be learning from the US, it's that the use of technology needs to be, monitored and checked and thoroughly understood in terms of the discrimination that even technology can impart on in terms of meting out justice. And technology it cannot be understood as being free of biases and prejudices, because the coding is ultimately done by the humans themselves. So right. So I'll end my presentation there. Thank you so much.
Invite the discussants. So please.
Uh, can you hear me?
Yes, sir, you're audible.
Okay. So, Dr. Singh, I think you wanted to go first. Please go ahead.
Please, you continue. Continue.
Okay. Yeah, thank you very much, Radhika, for a wonderful presentation. I think it raises a range of very interesting findings and very disturbing findings, which should be of concern to every police practitioner. And I think I commend you for this very thorough research. As a discussant here, I think I would like to raise a couple of epistemological and methodological issues for discussion. And I think just to illustrate my points, I would highlight one of your findings, which was that you pointed out that the highest level of satisfaction, 29%, was found in areas where the incidence of crime has decreased over the last 5 years. So I found it very interesting, and this raises important issues. I think there are linkages being made here, and there are kind of assumptions which need to be unpacked. One is that the satisfaction, one is with regard to police effectiveness in reducing crime. So it seems to suggest that if the police police work can reduce crime, and that as a result can lead to high level of satisfaction with police working. So if you just to kind of problematize this finding, I mean, there are a number of policing studies which show, on the one hand, that crime solving or crime fighting task is one of the many tasks that the police perform. And some researchers even say that it is many of the routinized tasks, in fact, consume most of the time of the police. So as a result, the crime fighting or detective role becomes quite marginal. So so the question to ask here is, to what extent can this be linked? Can the satisfaction of the people be linked with police quote unquote success in reducing crime? And second, I think we know that the crime is a social phenomenon. There are a number of factors which influence crime. So and when the police takes up crime fighting role as a mission, that is when there are risks of excesses being committed. So would we want the police to kind of, in a messianic way, take up a role which studies find that in any case its impact at best is marginal? We know, for example, how the rates of crime are measured. It is very often a function of registration and how crimes are defined, etc. So this colloquium is on evidence on criminal justice in numbers. So that also kind of made me think criminal justice in numbers or narrative by numbers as opposed to what? As opposed to criminal justice in words, criminal justice. What I'm trying to hint at here is that these numbers do tell a narrative, definitely. But as what are their limitations? So I would like you to like to invite you to kind of reflect on the limitations of the survey and how this evidence should also be questioned, and what kind of lessons can be drawn from this. So these are two broadly two broad issues that I wanted to bring up for discussion. And I very much enjoyed your presentation. Thank you.
Thank you. You're very right about, survey being a very limited tool of investigation in the sense that there are many issues, whether it's about, let's say, sexual crimes, or it's about um, the actually even police violence and the use of force by the police, which do not come out during this whole process of surveys. You cannot simply be going around asking people without the adequate resources. Um, um, Also, the surveys are prone to throw up information which might not be palatable to, researchers like us, and we then struggle to make sense of a lot of that data. So, for instance, we found in one of our surveys with the general public that the people are actually they condone police violence to a great extent. About 65% of the people feel that it's okay for the police to be violent towards criminals. And that's an attitude that's reflected in our media, in our, general sort of culture, perhaps. But despite all of that, I think that it's very important to be able to measure certain things. Um, Simply because this is an area which has been left untouched by researchers for a very long time. We've been talking in anecdotal terms, in terms of the personal experiences, etc., for the longest time, and we do not have any comparative representative data samples about what the larger trends are in our country. And if we compare our data to our researches to the Western countries, it's pretty evident that we've started this quite late in the day, actually. And yes, we need to move beyond surveys, definitely. But that will only happen once we have exhausted, I mean, at least this process we need to initiate and try to understand and then move on to sort of more refined methodological techniques. And the first point that you raised about, how satisfaction is related to crime, um, it's actually a bit more nuanced than that. And I mean, this is only a PPT, so we can only write as much in this. But if you go through our reports, which are available on the Common Cause website, you'll see that, so for instance, we know that Kerala has amongst the highest rates of crime. And like you said, the official rates of crime do not have anything to do with the actual sort of level of incidence of crime in that location. But also Kerala, in our survey, we found has the highest level of satisfaction with the police. So that corresponds perhaps with the treatment that the people are getting from the police when they actually go for the reporting of the crime or after that, and what their relationship with the police is like after post the the first interface with the police. And that is one sort of interpretation that I'm drawing from this data right now. But obviously, this is something that needs to be looked more deeply into. I hope that answers.
Yeah, thank you very much. Thank you.
So thank you, Radhika and Upul, for your interventions. At the outset, I congratulate Radhika for doing an excellent job and excellent survey. It was very comprehensive, and the conclusions are sharp, candid, and relevant. Presentation is also crisp and pleasing to the eyes, presented well. So I congratulate you on this issue. More or less, whatever has been concluded by you in your survey and in your presentation, I tend to agree. But it is only a trend. If you will go into the nuances, there are so many other issues about the methodology, as Upul has mentioned, which need to be worked. And since here people are there who are researchers and are members from different NGOs who are working in this field, I will raise certain methodological issues. Any survey should not suffer from two ills. And those two ills are statistician's curse, yes, and surveyor's myopia. Because if you will not be able to remove these two ills, your conclusions are going to be haywire. And that is why it is said that statistics hide more than what it reveals. I will not go into the detail what surveyor myopia or statistician's curse are, because you all are intelligent people, you understand that. I need not to go into the details. Let me come directly to the methodology which you have used. We should understand how a person shape his response. We all know we have been filling up so many questionnaires and giving our responses in different surveys. Our response is subjected to our personal experience or learning from others' experience or believing hearsay or acting on false notion based on ignorance and lack of exposure, as well as personal bias. In that scheme, I would like to refer your first slide in which you have said that 82% of the person whom you included in your survey were those persons who never contacted police in the last 5 years. Meaning thereby their response should be taken with a pinch of salt. Out of those 14% who had contact with police in the last 5 years, only 17% were those who were contacted by police, meaning thereby either police contacted them as an accused or as witness. Their response should be taken the primary evidence. If you are trying to gauge trust of people in police, because they are the first-hand responder, they are the primary evidence. Others' evidence is hearsay. For example, if you want to find out whether police torture people or not, the testimony of only those people who have faced arrest, who have been in police custody, is relevant. That is primary evidence. If you will ask in this group who have never faced police, who have never been arrested, and ask what is your response whether police torture or not, 50% of will say yes, they torture. So your data suffer from that myopia. That is why I say that quality and quantity of responder is soul of any survey. Whenever you want to find out answer to a particular question, select the responder very carefully, who have first-hand knowledge. Giving 10, 12 question in the form of a questionnaire to a group, and on the basis of that, concluding something may not give you exact result. It may give you a trend, that this is the general trend, but it may not give you accurate figure or near to accurate figures. For example, investigations. Mr. Pupul have already said that not more than 5% of the policemen are investigating officers. 95% are those who have never investigated a crime. I do not know how many of you have included in your survey were investigating officers or were people who have not investigated. And you are making certain general conclusions about investigations. That is what I told you, that it is that surveyor's myopia. I do not agree with your one observation that victims are unwilling to cooperate. 58% you have said, it is very high figure. A person who has gone as a victim to police, and on the other hand, you are saying he is unwilling to cooperate with police. It is not digestible. Either there was something wrong with the framing of the question, or the responders could not understand the question properly. Because if a person who has gone to police for help or for some investigation or some intervention, it is not agreeable that 58% will not be willing to cooperate with the police. Here comes the question of the proficiency of the surveyor. How we conducted the survey, who were those who went to contact these people? Either they were some students or they were some unknown people, you just handed over the questionnaire to them and they just got the questionnaire filled. Or they were actually some person who could explain the question or the questionnaire to those responders and could gather something meaningful. What I mean from proficiency of the surveyor is framing of intelligent questionnaire. Whether your questions were intelligent enough to find out the truth from that person. Avoid asking leading questions, yes and no. Whether police torture people, yes, police torture people. No. Try to find out the veracity of that responder by framing different questions in different ways. Avoid or ask probing questions, only then you will be able to find out the truth. Terms and concepts should be clear and they should convey the same meaning to all the responders. Okay, I'll conclude. Then there should be different questions for different sets of responders. I have already explained it. Another question, fear. Fear may be because of ignorance, because of lack of exposure, guilty mind. So fear is a very generalized term. I conclude by saying that the overall result of your survey are acceptable as a trend. However, if you want to study in minute detail, we should take care of all these aspects in our conducting the methodology of the survey. I again congratulate you. You have done an excellent job.
Thank you,
All the
sir.
best.
But that was quite yeah. So,
Not indictment, ma'am. It is honest opinion. If you take it indictment, then you will not improve.
if I may respond
If you will
to
take
that,
it as a suggestion, you will improve. And your quality of, yes.
So first of all, what I was presenting today were only glimpses of the findings that we got from our survey. These are four, each of them are about 200-300 long surveys and very extensive and very comprehensive. And because we are here to talk about how the problems need to be tackled, we very selectively for this presentation picked up some of the most troublesome sort of findings that came our way, which is not to say that there are no positives that are coming out through our surveys. In terms of the methodology that you pointed out, I agree with you that all of those issues one needs to be careful of. However, we like I mentioned, the um, the survey was conducted by the Center for Study of Developing Societies, which is well known for its researches. And they have been doing research on politics in India and the electoral trends for a very long time. And all of the points that you said about leading questions, probing questions, positioning of questions, asking the same question in multiple ways, defining the terms and ensuring that the terms mean the same thing to each respondent, everything was looked at carefully over a process of time by an advisory team, and we consulted external experts, including police officers like yourself, and some of the top, retired as well as serving police personnel were consulted before the whole process of survey even began. So it is to the best extent possible, we ensured that we took all of the opinions and all of the suggestions under consideration. And in fact, not just national, but also international colleagues, peers were who experts in the field. People like Andrew and Beatrice have been part of our brainstorming process. And therefore I disagree with you in I would in fact request you to actually go through the reports and look through the methodological section and see what a comprehensive, rigorous exercise we've been doing in terms of the methodology. And uh, the investigators that you mentioned, who are the ones who are doing the data collection, it's actually students from the MPhil and PhD programs from across the country who are, again, trained extensively. In their languages, the questionnaires are translated in about 11 to 12 different languages, depending on the location. And every group goes through at least 2 days of exercise. We do a pilot testing, we do a pre-testing, and only after all of these considerations are taken into account that we make changes and then roll out the final survey. So I I would again request you to please look at the main report. The other thing about contact with the police and your point of whether the general public has the know-all to be able to uh, have opinions on policing or not without actually having contact with the police. And I agree with that. And I realize, and which is why we point out that the perceptions often change after they have had interactions with the police. However, this trend of just a fraction of the population having any kind of contact with the police is consistent with trends across the world. We saw researchers from a lot of other countries, and we saw that just a very small population actually has contact with the police at all. And that does not, in my opinion at least, it does not devalidate the opinions of the overall, general public. And that is why we don't call this like a crime victimization survey or a police experience survey. It is a survey about how policing works. And like we as Indians, regardless of whether we've been to a court or not, are allowed to have an opinion about how the courts function and what the problems are in our democracy and in our justice system. I think to that extent, all of these opinions are valid. But of course, we give all our findings with the caveat that we display the fact that only 82%, 14% are saying this out of experience. And the same thing about victims being unwilling to cooperate. That is something that was reported by the police personnel themselves. And we can also give you sort of translated versions of the question if you think that there has been some problem in the way that the question has been communicated. I don't think that is the case. I actually think that this is something that maybe needs to be further probed as to what is it that makes somebody who's gone to the police once unwilling to go back again. And that's a question that needs more research. And, we've heard about anecdotes of, women who've reported cases of domestic violence or sexual crimes. They report it, but after that, they find it very intimidating to go back to the same process. And maybe some of those, sort of issues come into play. So,
Yeah, if I may, no. So on this issue itself, I just want to say that world over, the perception surveys do have their concerns, methodological concerns, and they are not free from some of the structural fallacies and inadequacies. Given the fact that we try to put as much as possible to maximize its objectivity and scientificity. But I suppose this is how the surveys are conducted and people are considering them. And methodology is, of course, looked at very critically. However, one very easy thing that most of the reputed world organizations generally do, that when you maximize your sample size, generally you have a better chance of smoothing the skewness in the data, which may be at times here and there. So suppose I do a opinion survey on a sample of 1,000, there may be certain findings which may cause some degree of concern to us. However, if the same survey sample size is expanded to say 50,000 or 5,000, then you will automatically see the things have a tendency to get patterned. And you can probably answer that skewness whether on a sample of 500, the same degree of results are there when you increase the sample size of 50,000. So that is one way to probably, that is how the people, that's why the bigger survey, like Pan India survey by MAR, like electronic, this election poll survey, the exit poll things, we sometimes do discuss these things. But on the whole, I agree with your methodology.
so actually, the sample size is significant. So for each of these studies, it's more than 10,000. One of the studies is
I am
15,000,
not
one is
saying
12,000, one is
there is
9,000.
a bigger methodological question. What sample size could be optimum or adequate? That I'm not indulging into this question, nor you need to do that. But I'm saying it depends on the kind of population you are trying to generalize with, as far as your study is concerned. So suppose I want to generalize a particular observation in the state of Punjab. And if I limit my sample, I'm saying that population of youth tend to believe police in certain way. Then I need not to take the all age groups. I can take the total youth population, say up to 30 years, and then I can generalize the trends that as far as this population bracket is concerned, these are the likely things to be held by the people in that strata. So this is how generally.
Yeah. So I
So
mentioned.
your survey is applicable to all age group?
Yes, we have clear bifurcation of the age. We do cross tabs across age,
No.
class,
What is
gender.
whether this opinion survey was concentrated on a particular
All
age group?
mature, all anybody above 18 years of age.
So now that age variation of age groups have their own sort of interpretation.
So that kind of interpretation you can actually see because our data is open and accessible.
Like I'll give you.
Anybody can do a cross tabulation and see what is the opinion and whether it changes across ages, across genders, across caste groups, across religions. And we were very particular about ensuring the representation of all of the different groups of the caste and religious groups in each state, in each location, as per at least the population
But I would again
in that
say,
region.
So
the only problem, the only problem happens if your results are seen independently without any there is no problem. But when you try to generalize it to the across the country to all the groups, then these questions arise. Otherwise, absolutely acceptable. So if I ask whether a particular group, then we have to say what was the representation of that group and participation of that group in that survey.
So the state-wise data, actually, you can see in the report
Okay.
also.
All right, I
So-
can imagine. Yes, Balay.
Sir, thank you. No, I think the policing and what we need to improve and what is good about it can be discerned from not just surveys, but also from the hard data that state police departments themselves provide to national agencies. So maybe that's one way to complement such presentations in the future. So that, there's allegations of subjectivity, which are legitimate, but can be countered more effectively. So I was just saying that maybe we could have a round of questions, not just on this report, but how data that police departments themselves are providing year on year, including certain crime data, how is that being used? Because we see that sanction strengths increase very marginally for police departments and vacancies are still not getting filled. We also see some patterns in the filling of vacancies, and there is a variation between, say, the SC, ST, OBC category and then general category. Other concerns about policing that are borne out by the police data itself. So I'm just wondering if there are any questions or comments on such topics.
I just want to respond in a limited way from your data only. You have mentioned that police is working on strength, which is 40% less or 77% you have, I think, mentioned that. You have actual capacity and there is shortfall of 32%, 33%. But if you will see the data on the basis of which she has calculated the 77% strength is of that era when that police station was sanctioned. When these police stations were sanctioned 20, 30, 40 years back, they were given 20 policemen or 30 policemen. That sanction has not been revised. Still, it is continuing the same. So that does not reflect the actual situation. So there are so many.
Question for you, Radhika, and like I congratulate you on the presentation and the work, and I think I agree with you. I disagree with that methodologically it looks very, very sound. I just wanted to ask if in your research and when you were doing any sort of like the literature review, if you did come across any sort of the police auditing themselves kind of report where the BPRD might have done it or any police department might have done it, where the police is looking at its own problems and trying to figure out how to improve.
No, we didn't. But we weren't even looking for anything of that sort.
Right.
We did come across PAG reports and all of that, but nothing from within the police departments.
Hopefully,
But
was saying something.
Yeah, so I just wanted to make a brief intervention, just to make sure that my earlier intervention was not misinterpreted. What I was, driving at, I was not trying to undermine the importance of these kind of perceptions or the kind of subjectivism that these surveys bring out. In fact, what I was trying to drive at is that uh, any survey, however reliable and complete it is inherently limited in probing the deeper underlying questions. So I think my perspective kind of differs from the interventions earlier made in the sense that uh, some people would want the survey to be as the best and expect it to tell everything. Uh, my point is that it is inherently limited and it can only tell us a few things. And for other questions, for even raising other questions, you have to look at more not just the statistical reality, but also the sociological reality, which any survey is sort of not capable of addressing. So in no way I'm undermining these perceptions, and nor do I think that policing, because it belongs to a social world, can be measured as a thing which can be measured in a natural world. So there will obviously be subjectivism, interpretivism. That is not a flaw. We have to embrace it. Uh, what I was trying to hint at is the inherent limitation of survey, of a quantitative method, and how it needs to be supplemented with qualitative studies. So my stand is a little different from the other interventions that have been made. Thank you.
I have a right to respond because everybody is criticizing that I have not accepted this survey. I told you in the beginning, as a trend, your survey is acceptable. But if you say that 40% or 44% of the people believe that police torture, I'm not going to take that figure unless people who have been tortured have been interviewed by you. I conducted this survey during my research work when I was doing my PhD. I took response from judges. I took response from police officer. I took response from the person who are inside the jail, because at that point of time I was posted in jail. I took response from them. I took response from general public and found a wide gap. So I am questioning only the 40% figure. I'm not denying that police is not torturing, but saying that 40% believe that police is torturing, I'm not going to take that. You have to work on minute detail if you want to give this type of conclusions. This is my objection.
One more clarification, Dr. Very important point. So are we taking perception to be wrong or right? Correct or incorrect? Perceptions are not in this binary where you can say that custodial torture by 40% police officer may be incorrect, but people believe so. That fact will continue to be there. People's system of belief is not always attributed from the fact. What Radhika also says, that I have a right to opinion, I have certain way to think of police, and nobody can snatch me. So under that belief system, I am attributing police to be brutal, you know. And so it's hard. So as far as you are concerned, there is a relief for you that the police is not indulging into factual custodial violence. This is not emerging from the survey. However, the people can continue to hold this view that police tend to torture more than 40. But all opinion and perceptions are not necessarily the factual statements. That's it.
One last word, one last sentence. Why we conduct survey? To correct people's perception. If we will conclude our survey on the basis of perception, we will compound the problem. Therefore, survey should be as accurate as possible if we want to make proper perception about police. This is my concern. If our survey will also be based on perception, then perception will never change. The problem will be compounded. So in general, trend, I agree, but in minute detail, I have my right to disagree. Thank you.
So I just have one question for you. As a researcher, I've been to 20 police stations, where in 5 of them I've seen the police torture people in front of us when there were external people in the police station. Would you consider me as someone who's qualified to have an opinion on whether the police torture?
I respect your opinion, madam. I'm only asking her how many people who have been in police custody have been interviewed to make that 40% figure. Can you answer that?
So actually, again, what...
Not perception, madam. It is a question of survey. If you will make your conclusion in the survey on the basis of perception, we will end up nowhere. Surveys are to correct perceptions, to give correct perception about things in the society. Otherwise, generally people believe police torture. What was the need of this survey?
If I may add to that, I think so far as the accused is concerned, the accused has to be produced before the judicial magistrate within 24 hours. And he has to physically even examine the accused and at the medical records. So there is a judicial check as well.
So, in terms of who the respondents were and whether victims of police torture are the ones being, uh, like Upal sir had mentioned, and I agree with him that surveys have their own limitations. And this is one glaring limitation of a survey process itself, that people would not be forthcoming to come and say that I was accused of a crime or I was in jail because of the social and the, several layers of stigma attached to this issue. And we tried doing that, and we considered that in a lot of our meetings about thinking about how we can, focus our surveys around that population. But that in a survey format, at least, we didn't think that it would do justice to, the ground reality. So yes, this data doesn't represent those who were actually tortured, but that is also very difficult to capture.
Thank you, ma'am. I think we can have discussion over lunch, please. So I invite you all for lunch in the multipurpose hall. Thank you. Thank you, Mr. Datta. Thank you.
ओके ठीक है बिल्कुल ठीक है आ रही है बात मैं अनम्यूट भी कितना है अपना हाँ हाँ
Good afternoon, everyone. We'll begin with the next session. The topic for the session is prison reforms using data to identify key issues and solutions. Presenter for this session is Ms. Sugandha Mathur from Commonwealth Human Rights Initiative, and discussant for the session is Dr. KP Singh. I request you, ma'am, to please briefly introduce yourself and begin with your presentation. Thank you.
Hi, good afternoon, everyone. I guess all of us know each other by now, and it's been a really wonderful session so far. Last 2 days, very, very enriching. It is generally very difficult to have sessions post-lunch. So I would try my best to keep myself and all of you awake. So I have been associated with the Commonwealth Human Rights Initiative for the past 11 plus years, and I particularly am part of the Access to Justice program looking at prison reforms. So should I begin? Okay. So in this presentation, I would basically I'll try to cover few areas that in which we have tried to use data and, the kind of, if I can say, a kind of impact we've had using that data, and therefore, the point that we need to go back to data again and again, and we need, the data at the local levels, at the district levels, the most. So overall, the CHRI's approach to research and advocacy, I mean, we are basically a research and advocacy organization, is to achieve the practical realization of human rights. And through our research, our endeavor is to identify the implementation gaps. So what is on paper versus what's on ground. So, we compare, the standards on one hand, and then see the implementation of those standards on the other and where the gaps are. The second is where we see that there's something missing in the policy itself. So we try to identify through our research the policy gaps as well. And as most of us researchers here, data as an important tool of research and advocacy for all of us, and it has enabled us to engage with the system, connect with the functionaries, act as a catalyst to build dialogue and facilitate collaboration, as we have in the form of IJR. So with that brief introduction, though the scope of our work under the Prison Reforms Program at CHRI is quite broad, but for today's presentation, I'm limiting it to these 4 areas. So first being the prison management and prison conditions, second on prison monitoring, third on the coordination between prisons and other functionaries, and fourth, access to legal aid by prisoners. So the first section on prison management and prison conditions. So this, I would like to share our experience of conducting the all prison studies in a few states. And this all started with the order of the Honorable Supreme Court in inhuman conditions in 1382 prisons. This was a writ petition which was instituted in 2013. And by this, one of the orders in 2017, in September 2017, the Supreme Court directed the state legal services authorities to conduct studies on the overall condition of prisons. And in fact, they quoted one of our reports in the order, and they said that similar reports must be conducted in all. That was a Rajasthan specific report, and they asked us to, ask the SLSAs to conduct similar reports. So as a result, we were approached by the state legal services authorities of Haryana, Punjab, and Karnataka. And we got these 3 all prison studies in these 3 states. I would like to particularly talk about the Karnataka study because I've been, I was one of the main researchers and part of that study. So the methodology was for us when we designed the study was that, first we sought information. We developed a comprehensive pro forma based on which we asked for information from every prison. So at that time, there were about 51 operational prisons in Karnataka. And we asked very specific, data sets that we asked prisons to respond. So for example, on prison infrastructure, the number of barracks, the number of wards, the number of even, the lights, fans, the basic infrastructure facility that is there in prisons. On prison occupancy, we asked specific questions. We segregated the data based on gender, on the prisoner type category, and we asked them information about the period of detention of prisoners, the inflow and outflow of prisoners in that particular prison. What is the level of staff vacancies at different levels from chief superintendents to the warders level, the conditions, the status of medical facilities, how many, whether there is a full-time medical officer visiting or, there's a visiting doctor from a nearby local hospital, what kind of medical facilities are there, whether there is a dispensary, whether there is a prison hospital, and whether there's a pharmacist, any nursing staff. It also included, we also asked questions particularly in regard to the treatment of mentally ill prisoners, their periods of detention. Questions were, data was asked about the communication facilities, phone facilities available, for communication with the family or with lawyers, what kind of facilities are there. Oversight mechanisms, we mainly included whether whether board of visitors have been visiting or not, how's the under trial review committees functioning, the issue of police escorts, particularly, and the VC facility was introduced at that time. So how many prisons are equipped with that? How many people have been produced physically? How many people have been produced through VC? How many people have not been produced at all, either physically or through VC? So, I just want to give an idea of that, the kind of questions and the data that we asked from every prison before we visited these prisons. And that helped us to, sort of go a little bit deep into when we visited the prisons and asked, inquired little more in detail as regards the particular, the infrastructure and other facilities in the prisons were concerned. And then when we visited, of course, there was an element of direct observation to different areas of prison when we visited. This was followed by semi-structured interviews with prisoners, under trials, convicts, women, young offenders, foreign nationals, and we also interviewed prison personnel at different levels. So we tried to get in perspective from, the senior as well as the junior staff in the prison. And so after the, immediately after the prison visit and interviews with the prisoners, it also helped us to sort of take up some individual cases here where it required the urgent attention of the authorities, whether someone required medical assistance, whether someone required any legal assistance. So we accordingly wrote letters to the concerned DLSA and the prison, and we tried to address some of their urgent needs. So broadly, this report runs in 2 volumes. The first volume has a thematic, analysis of our data. And in volume 2, we purposely made an effort to come up with prison-wise reports, because we thought that that will be very, very relevant for the concerned superintendent of prison or the DLSA secretary in that district to see, what is the condition of the prisons, what needs to be done, what is good, what is bad. So that is what we tried to do and make the report as comprehensive as possible. I'm not going into the details, but these were basically the 15 thematic areas, based on which we collected the data and we analyzed the information. Now, what has changed since 2019? These visits were conducted in 2019, and we recently did this exercise in April 2022. And we wanted to understand, whether anything has actually changed on the ground or not, and how data can really help us to make that change, or is it irrelevant to look at data? Right? I don't want to sort of say that, all these changes happened only because of our report. Of course, you need, the interest of the prison department, you need the will of the state government. And in the case of Karnataka, there was a suo moto petition, which was also going on in the High Court. So the High Court also pushed, for certain things, and our draft report was submitted to the High Court at that time. So it kind of, fortunately, it worked for us, where everyone tried to sort of contribute towards making something right, right? And of course, this was the time immediately after our study. This was the COVID period, and where the attention to the prisons had also come. So all that sort of helped in getting some positive change on the ground. So, for first thing, so for example, about the prison occupancy rate, I was also discussing this yesterday. So when we look at the state level occupancy, it was only 101.7, which doesn't sound alarming. We feel it is okay. But when we look at the prison-wise occupancy rates, it was much, much higher. And in certain prisons, it was even above 200%, which is critical sort of overcrowding as per UNODC standards. And so the impact has been that the state government has now allocated funds for an additional capacity to be added in prison. So they have allocated some 450 crores for the construction of new prisons and also renovate the older prisons. In Karnataka, there were only, out of 51, only I think 12 prisons which were which were constructed post 2000. The rest of the prisons were very, very old. And there was one prison which I went to, Vijaypura. This was actually set up way back in some 1645, and it was used. It used to be used as sarai, at the time of Aurangzeb. So. So that was the kind of conditions some of the prisons had in Karnataka. On the issue of staff vacancies, in 2018, the condition was pretty bad, understaffing with less than half of the required staff strength. And this was, of course, already under the attention of the prison department. So they did a massive recruitment drive in 2019, where they appointed 1,070 warders and 32 jailers. One of the good practices was that they took into account the 33% women ratio. And I think Karnataka was one of the few states, or the only state which at that time they had women in prison staff, and up to 33%. They also so when we also look at the medical personnel ratio, the inmates to medical personnel ratio in Karnataka, it was pretty bad. So 664 inmates per medical staff when we look at. However, when we look at only the medical officers ratio and include the visiting doctors as well, the visiting, I mean by the local district hospital, then it ranged between 250, 300 inmates to one doctor, which was, again, that's also bad. Then, the prison department undertook, the appointment of medical staff as well, psychiatrists, nursing staff. This was something that was highlighted by our report, that the prison staff were facing on a day-to-day basis on to take care of prisoners, who were getting treatment from outside, but there was no one to take care of them once they were they shifted back from the hospital. So there is a need to have nursing staff in prison. And they also appointed some paramedic officers to sort of bridge the vacancy gap. Regarding prison infrastructure, the conditions were pretty bad. Basic things like RO plants, to have potable drinking water, this was not there in 25 prisons. Phone facilities were only there in central prisons. Again, central prisons were quite equipped, but the conditions of district jails and sub jails were not, I can't say that up to, did not have minimum standards. The interview rooms were in a very, very bad shape, even in central prisons at that time, except for Bangalore. Issues, I mean, I visited some very, very, horrible places of staff quarters, and so all this was highlighted in our report when we looked at the infrastructure-wise. We also did an analysis based on the standards which are given in the Model Prison Manual 2016 about the inmates is to toilet ratio. And this was highly inadequate in most of the prisons in Karnataka. So based on that, if you see on the impact side, now a lot of things, and I mean, we were very glad to see that, a lot of things have improved. Now, we did not obviously have the time to go back and visit these prisons to verify this data. So we requested the DLSA secretaries through the state legal services authorities to actually go and see whether these changes have actually taken place or not. So that was the process of validating that. One interesting case of revenue prisons that we found in Karnataka was, so few states have this concept of revenue prisons. Maharashtra has, and Karnataka. And when I visited, some of these revenue prisons, I think I mean, this is the most inhuman and most degrading, treatment to prisoners that I have myself witnessed, through when I visited these revenue prisons. So, so these are basically the prisons who are under the revenue department and not directly under the prison department. And so they do not have an open space or as a complex or a compound as most of the other prisons are. Even sub jails have, even though small, but they do have certain open space, and there is regulations and timing, the lockup timings, the open timings, all that. So this was basically just 2 or 3 rooms in the Tehsil office, which were designated as revenue prisons. So people were practically locked up 24/7. And I mean, the conditions were appalling. I mean, I really can't explain, the kind of, and this, initially we thought that probably these are cases, where people are supposed to stay only for 1 day or a 2 day, or it is, cases which are dealt by the executive magistrates, or, like, which are not very serious offenses. But in some of the subdivisions, any criminal case which was, coming to the court, the accused were, were staying in these revenue prisons. And so I met someone who was in such a condition of 24/7 lockup for 2 years, and he could not even walk properly when I, asked them to open the lockup and to actually wanted to talk to him. And on the matter of data, because they were, these prisons were basically managed by Shirastidars. This is lower than the post under Tehsildars. And they had no training of how to maintain or record data. So when we ask them, when we send them the pro forma or data, we wanted to ask them, they absolutely had no records, and for how long people have been there, and what case, what court, absolutely nothing. So and to our surprise, I mean, I feel this was like a big failure on the part of the administration, where none of the judicial officers, no one from the prison headquarters had ever visited these prisons. So we did not want, for our final report and then, to be submitted and then something to be done in this regard. So we submitted an urgent report to the SLSA and then to the prison department. And it almost took them 3 months to, finally shift these people from these revenue prisons to the nearest district or central prisons. And the proposal to then now completely shut these revenue prisons is pending with the state government, but like really horrifying situation there. As regards, some issues regarding convicts, regarding prison labor. So we found that 55% of the convict population detained in central prisons and in open prisons were provided some work. And this amounted to only 14% of the male population in prison. So, and out of that, 90% of them were actually male, and one of the issues with the wages were that several prisoners had to, they did not had Aadhaar cards or any other valid document to open bank accounts. So their wages were only written in registers and they could not really secure their wages or, send it to their families or anything. The Karnataka government, they in October 2021, they came up with the Prison Development Board Act, which that is what they claim that now, they would be able to provide better vocational training and better facilities and work opportunities for convicts. So we hope that that happens. And the issue of these wages, this was sorted when they they collaborated with the state bank, and finally the Jan Dhan accounts were opened for all the convicts. So I just trying to again and again trying to make that point that if this data would have been available earlier, or that right attention would have been given to this, then probably this a lot of issues could have been sorted at the district level itself. Coming on to the next section on prison monitoring. So we have been monitoring this oversight mechanism called Board of Visitors. This emanates from the Prison Act of 1894, and every state prison rule has this system of Board of Visitors, and since this sort of comes from, this comes from the British legacy. So this is very much dependent on the idea of having an independent monitoring of prisons. We know that prisons, the closed nature of prisons, and that, and the chances of human rights violations being higher. So therefore, it is important that prisons are monitored regularly. And there are official visitors and non-official visitors. Just to explain briefly what this mechanism is about. So official visitors and non-official visitors together constitute Board of Visitors. And official visitors are those who, by virtue of holding certain official positions, for example, the Chief Judicial Magistrates, the District and Sessions Judges, the DLSA Secretaries, they are supposed to visit prisons. Administrative officers, the district magistrate, DCs, the chief medical officer in the district, so basically the idea is that whatever you need in the society, you also need it in the prisons, right? We can say that prisons are like a microcosm of society. So whatever, the heads of all these departments who are there in the district are basically the official visitors to prisons. And then there are these non-official visitors who should ideally be people who can contribute to prisons, doctors, social workers, retired officials, lawyers, journalists, and then ideally they should be appointed as visitors. Unfortunately, that does not happen in most of the states. We see that they are the political appointees Not that we have an issue with that, but if they're trained properly and if they know how to really monitor prisons, then I think this can work. But this is the broad sort of an overview on the mechanism. So this is, I think we are the only organization in the country which is capturing this data, on whether these board of visitors are constituted in the country or not, and whether so this is not covered by the NCRB Prison Statistics India. What it covers is overall the number of visits by judiciary. So judicial visits, medical visits, executive visits, and then there is the category of other visits. So, but per se about board of visitors and whether these non-official visitors have been appointed, and whether so every quarterly they are supposed to have this meeting, board of visitors, whether that is happening or not happening, that is not captured. So we've had worked on this issue. I think this was the first issue that we started working with, and we've had state specific reports that we've done in various states, and that was an organic progression of our work, where we expanded the scope of our work pan India, and we conducted with 2 national watch reports, 2016 and 2019. So what has changed since 2015 and 2018? If you look at the data, can't say much, maybe slightly better off. So 7 states did not have NOVs in 2015 or in 2018. 9 states did not have BOVs. Slightly, the number of, there were 14 states where the number of jails which had NOVs slightly increased. So more or less, not much of a change, but you can, I mean, there's obviously a long way to go. But again, something, coming back to the data, that this is something that is important and should be sort of there in the government data, but how do we sort of get it there is the big question. The third section is about coordination between prisons and other functionaries. I've only dealt with one mechanism here, which is the under trial review committees. This is something which was set up by the Supreme Court in the same writ petition, re-inhuman conditions, and in April 2015. And this is basically a district level body which has, it's a 5-member committee headed by the district and session judge, with superintendent of police, district magistrate, the superintendent of prisons, and the DLSA secretary as its members. And this was basically, set up by, because the Supreme Court was concerned about the high under trial proportion of prison population, and they thought that it's important to have a mechanism where these cases could be reviewed periodically and ensured that no one remains in prisons for the barest minimum period that's required under the law. So no one should be detained more than that. So I'm not going into the details of it. So the Supreme Court laid down some 14 categories that these UTRCs are supposed to identify and review these cases, and ultimately help, if some correctives could be applied, and if anyone could be given a benefit of bail or anything, then that could be done. So we have done 2 watch reports on this. Again, this data is not captured by PSI, and NALSA captures this, but in a very limited way, on the number of meetings held and number of cases identified, recommended, and released, but nothing beyond that. So through our these 2 reports, we've tried to do a detailed analysis of the minutes of these meetings, and what really functions, what doesn't function, what are the challenges that are faced by DLSA secretaries, prison personnel, and in dealing with this. So the first national report that we conducted, it was also submitted to the Supreme Court in the same writ petition. And so one of the, the impact of it, because there was so much of discrepancy found in the functioning of these UTRCs across the country, that the court directed NALSA to come up with an SOP, standard operating procedure on the functioning of these UTRCs. But I mean, of course, it does not sort of help, and it does not say that, okay, now all problems are solved and everything is in place. But it definitely helps to sort of move forward. And it's a continuous exercise where now you have to, review this. How is this SOP functioning? What is the, what are the gaps there, and what are the challenges faced by the functionaries there? And we've recently come up with a next, the second watch report, which is on 2020. But again, I mean, still, we are dealing with a lot of same issues that we were dealing with when we did the report in 2016. So again, a long way to go. Very quickly on the last bit on the access to legal aid by prisoners. So this was a comprehensive report that we did on the functioning, on checking the implementation of the 3 NALSA schemes, particularly in regard to persons in custody. And these are all RTI-based studies, the BOV study, the UTRC study, and even this the legal aid study. And we have Mr. Chauhan with us. He was at NALSA at that time, and we were very, sir was very gracious to, to take on, most of the findings of the study and, make certain, NALSA took it very seriously, and certain amendments were brought about in the regulations based on the findings of the study. I'm not going into the detail because the time is less, but one question that, that I want to ask all of you is that because this data is not available in the public domain and is not recorded by the government, how do we institutionalize this in the government data? I mean, we've tried, but what could be the way of institutionalizing it where, CHRI does not have to do it, but, a government agency takes it up? Thank you.
Thank you, Sugandha. I have no disagreement with you. I served in the prison department for 5 years, from 2010 to 2015. And I was part of the committee which drafted the Model Prison Manual 2016 and wrote 4 chapters of it under my supervision. I was part of the NHRC team as well as the team of the MHA, which drafted the Modern Prison Act. So I knew ins and outs of the prisons. So I have no disagreement with you. However, I have certain issues which you have already mentioned here. Jail is a low priority area for government. If you list 2 department of government, it is amongst the 2 lowest priority area. Nobody listens. No politician is interested. Even the prison officers, they are not interested because it is the strength for them and they create exploitative environment inside the prisons and get benefited out of it. Conditions of women and infants is, I cannot imagine. And when I saw it, I wrote 2 novels in Hindi on conditions of women in prisons. One is titled Bandini, another is titled Daldal, has recently been published by Vani Prakashan. Condition of women is just like hell. There's no work for them. They are locked 18 hours a day. Their infants are locked 18 hours a day with them. In fact, you have not mentioned it, you should mention it. Infants have no place to remain in jail. When we have child welfare committees under JJ Act, it should be their responsibility. What to talk of mentally ill prisoners? Jails are not meant for mentally ill prisoners, but you go to jail, you will find few in every jail. Again, that is corruption based because their treatment is very costly, their medicines are very costly, and it is a huge racket in jails. You have mentioned about NOVs. I kept on trying for the last 10 years, from 2010 to 2017, could not convince Haryana government to appoint NOVs. They are afraid that if people from outside will go in, the things from inside will get exposed. Payment of wages. It took me 2 years to enforce that prisoners should be paid wages in their banks, because it is again a corruption racket. The jail superintendent, they draw the wages, keep it with them, and when the prisoner is going out, they will ask him to sign as if it has been paid to him, and they'll keep the money. It took me 2 years, and I took certain punitive action against some jail superintendent. But now in Haryana, you might have visited, the wages are paid 100% in bank accounts. Food, menu, and timings. How many of we can eat a food every day, dinner, which is cooked at 12 o'clock during the daytime, served at 5 o'clock before sunset, and then they eat it at 8 o'clock. They have to heat it. For heating, they need coal. For that, they have to pay extra amount. Do you know what is the cost of coal in jail? Outside, it is 10 rupees per kg. Inside, it is 50 rupees per kg. Number of UTs. Some judges are here. The statistics say it is 76%. It is actually 90%. If you calculate the footfalls of under trials and convict in a jail, it comes out to be 90%, because most of the UTs are bailed out, so they are not accounted for. It is 90%, and 54% of them are bailed out within 90 days. 34% of them are bailed out within 30 days. I do not see the logic why they are put to jail for 30 days. Drug abuse is rampant. It is up to 60% in Punjab jail, up to 40% in Haryana jail, up to 20% in Himachal jail. It may be varying in different states, but there is no drug addiction facility in most of the jails. Reintegration program, we say we sent the convicts to jail for reintegration, but there is no reintegration program. You missed an important statistics. 98% of the staff posted in prisons, they are security staff or discipline maintaining staff. Only 2% are for correctional work. And among those 2% also, 1.5% are medical staff. So there is hardly any staff for correction, whereas the purpose of sending a person to jail is correction. The tag of convict remain attached with them even if they have served their sentence. Even in government jobs, they are disqualified. Nobody is offering them job. Aftercare program is totally absent. It is nowhere in India. Contact with the outside world in states like Punjab and Haryana, we have formalized it. But in most of the state, telephone facilities are not available. Remission to good conduct prisoners. Most of the state, they do not have adequate policies. Suspension of sentence, respite and reprieve. These are the provisions in Criminal Procedure Code and in Constitution. The procedure of, or this concept of respite and reprieve, they are mentioned in Article 72 and 161 of the Constitution of India, but we have not used it. We have not even defined it what it is. It can be conveniently used for pregnant mothers, for those who are lactating mothers, just to give them respite and reprieve till the time the need is there. Staff strength, ideally BPRND you have mentioned, it should be 1:6. But if you will go by actual account, you will not find it 1:15 or 20 even. And that staff, again, I told you, only 92% of, only 98% of the staff is security staff, 2% is for correction. Toilets, you mentioned in Karnataka, 1:2021. The BPRND manual says it should be 1:10. There used to be a jail about 10 years back in Haryana, where a person used to be in queue at 5 o'clock in the morning, and he used to get his time to use the toilet at 5 p.m. after 12 hours. Situation is now improving. I'm not saying it is so, but situation is improving, but not at the rate it should have. Work. You mentioned that 40% or whatever, but all India figure is that only 20% of the prisoners who are convicted for rigorous imprisonment, it is the information for the learned judges who are sitting here. we are able to give work only 20% of them. 80% of the prisoners who have been sentenced to undergo rigorous imprisonment are going out serving simple sentence. I said it so about 3 or 4 years back in front of a Supreme Court judge that it is contempt of court because the prisoners are not giving work. Prison statistics, you have said, need to be improved. I agree totally with it. And legal services authority. The judges are sitting here. There are a lot of complaints about the advocates who are providing legal services authority. A lot of corruption, a lot of money, and not giving quality services. My time is over otherwise. Walia will again show me the figure. I stop here, but I have many things to share about prisons. I have said enough. Thank you now, your intervention.
Is there any other questions from the audience?
Under trials. As you said that there may be 90% of the under trials. If you do not ignore the persons who are admitted in the prisons in a year, like for instance, 75,000 women prisoners enter the prisons, but on a given point of time, there are around 17,000 only. So in data, we ignored that 75,000. However, let's see some other aspect of the entire scenario. Total number of criminal cases pending in the courts at a given point of time are around 2.6 crore at a given point of time. And at a given point of time, total number of under trials are 3.68 lakh, right? Take out the percentage. So out of the total criminal trials, only 1.72% prisoners or the persons who are facing the trials are inside the prison. So 1.72 figure is never projected. Be that as it may, but the fact remains that there are number of unnecessary arrests. Remands are also given in a routine manner. So we have to improve upon the same. As far as legal services authorities are there, quality issues are there. But what is happening now that we are changing the models of legal aid. So I hope that it will improve the situation in the coming months, years. Yes, your observation is correct. The number of under trial inside prisons are only 4%. 96% are bailed out. But the question which is being raised is why a person is sent to prison for 30 days in petty offenses? Why not grant him bail? This is the important question. That is there. One point I want to add. And about a month back, there was a program in Vivekananda International Foundation, and one Chief Justice of High Court was also there, and certain other luminaries were there. I presented a case there. Why we are not able to reduce the pendency of cases and pendency of the under trials? You are supposed to decide 120 cases per year. In Haryana, we have 120 units you have to earn. You have to decide. Whereas average registration of a case in a police station is 500, 600, even up to 1500 in bigger cases. So 85% of the cases are being added to pendency every year. So I raised this question in front of those judges. Why can't we have more than one magistrate in a police station jurisdiction? Why it is only one magistrate, one police station? Have 3, 4, or 5 judicial magistrates, depending upon the need. And then you can say that we are reducing dependency. Otherwise, the mountain is piling up. And you very rightly mentioned legal services. There is one more aspect. If you see the total number of arrests in 1 year, there are around 60, I think 67 lakh arrests are there. But 51% of the arrested person do not enter the prisons. If you see the data, this year, if you in the year 2020 itself, 76% of the arrested persons were given bail at the first instance. They didn't enter the prison. So that is a good figure. And the total figure is about 1 crore 40 lakh. If you add the figures of preventive arrest in that, the total arrestees in a year is 1.4 crore. And the possibility of a person being arrested during his lifetime is 40% if you interpolate it mathematically. Another thing, you will find in jail persons arrested under 109 CRPC, whereas that provision has been deleted from CRPC in 2009. Still, police is continuing with the arrest, and the executive magistrate are remanding them to jail if they are not able to give bond or if they are not able to punish Jamantis. So, many gray areas so far as prisons are concerned, and all these stakeholders, I'm not blaming any particular organization. Police is the biggest culprit. They are arresting people unnecessarily. The advocates, when Section 41 was amended, the advocate went on strike, kept on strike for 1 long years. And the strike was broken only when the government agreed to dilute some of the provisions. So all the stakeholders, they want that people should be arrested, they should be jailed. They are clientele for them, for everybody. They are not victims or they do not sympathize with them. They are clients with them. They are the clientele. So it is a vicious circle and we have to break it if we really want to do something good for the victims.
Sir, I think we have the guidelines of the Honorable Supreme Court in Arnesh Kumar case, where it was stated that in cases punishable with up to 7 years, there ought not to be any unnecessary arrest. But on the field, it is observed that we have so many arrests in offences punishable up to 3 years, up to 7 years. And the issue raised that why bail is given if he ought to be the prisoner, the accused ought to be released after a short span of time. The reason is that remands are sought even in cases of theft and offences punishable up to 7 years. And they insist that the accused be sent to custody for investigation or for tracing the criminal history of the accused or for the interrogation of the accused. And when they do not come up with the criminal history or when they do not connect, they cannot connect the accused with the crime, then the accused is given the bail.
Since you have raised this issue, I have discussed this point in that in detail in that conference itself. The word mentioned for interrogation or for recovery under Section 27 is police custody. And in a number of cases, Lister versus Empress, Harkishan versus State of Haryana, I can list a number of cases where the Supreme Court has defined what is police custody. Police custody does not mean the person should be arrested. Police custody means direct or indirect control over the movement of the person. If police want to make a recovery, why they want to arrest him? They call him under notice of 160, recover whatever they want to recover and let him go to jail, let him go to home. But the police will not like to forego their powers. The powers of khaki is only in arrest. The advocate will get job only when person is arrested and produced before the court. And I will not comment about the courts.
The commissioner gave the report that the police officer was not aware of the guidelines in Arnesh Kumar. Because
and excuse me for saying so, sir. Who is responsible to implement Arnesh Kumar? It is the magistrate who is given the duty that see that guidelines are followed. And if the guidelines are followed, he should take action against the policeman, write to the SP to write that he has violated the guidelines. You order registration of a criminal case under Section 166A IPC that he has violated the procedures. How many of the judges have done it? I asked this question in front of the High Court judge. That how many of the judges have written against police officer who have violated Arnesh Kumar?
So that will already.
How many of the judges have been held for contempt for not following Arnesh Kumar?
That will add again thousands of cases to already crores.
Doesn't matter. But if we really want to improve situation, we have to act.
One thing, so far as the contempt against the police officer are concerned, the magistrate did it. In the very evening, the commissioner of police have called me that look here, your magistrate has wrote a contempt against the police person. This is a basic problem. So far as police excesses or judiciary is sleeping over it, that is a different thing. But just now, these figures which you have gathered regarding the prison reforms, they have mesmerizing effect. Presently, 16 points program has been provided. These 16 point data has been collected from the prisons. What we find that 30 prisoners in the Noida jail were of the prisoners under section 151 CRPC, 106, 107, 116 CRPC. I called the commissioner. मैंने कहा under what circumstances they are in. When under section 151, they only 24 hours arrest and they are languishing in jail from last 30 days. And then I have just warned him that if by tomorrow they are not being released, then I am going to write it to Honorable the Supreme Court. And on the very next day, all these persons have been released. And what their rationale was that they could not give the PB and the sureties. Manika, that is not there. So this is the basic, the ground reality is something very different. We all are acting on the basis of the judgments of the Honorable Supreme Court. And we are trying to enforce it. But the police persons, what they say, कि साहब अगर एक बार ये भाग गया तो हम उसका इन्वेस्टिगेशन कैसे करेंगे, हम उसका बयान कैसे लिखेंगे?
I agree.
Otherwise, you are keep on confronting with the police authorities. Keep on.
I agree. In that presentation which I was discussing, I recommended certain changes in section 41. Policemen, when the Supreme Court restricted their power to handcuff, again gave these arguments. But now they are used to it. They are not handcuffing in most of the cases. Rather, there may be exceptions.
कोर्ट के बाहर तक लाते हैं हैंडकफ, कोर्ट के अंदर वो कप जो होते हैं वो बाहर फेंक देते हैं. Once I was inspecting the court, I found many handcuffs outside the court.
Still, compliance is there for 80-90%. I can agree. But you act tough. Start acting tough. Because it is you who have to enforce the magnanimity of law. If you will not act, policemen are happy using their or misusing their powers. So we have to act. Or combinedly, we have to act. This is what I wanted to impress.
Yeah, sir, also there is sometimes a requirement of, I think, awareness about the decisions also. For example, IT Act Section 66A decision, when it was supposedly read down, even after that, there were 22 arrests made in the whole country. 4 of them they were in Maharashtra. So we had to appear before the Honorable High Court to say that, see, by any chance, they do not look like foreigners. Because the point is that this whole decision has been, again, like, by the media, by the, even news people have been absolutely misinterpreted. So basically, the decision says that only under Article 19, 66A is a violative section. So 19 is available only for the citizens of India. So basically, it's applicable that, 66A is not for Indians. But unfortunately, the people who are getting arrested are Indians, and possibly what exactly it says has been completely misinterpreted, and continuously police were saying that nahi, power hai na, we can arrest cognizable offense. IT Act provides for all cognizable offenses.
Right.
So somewhere there we need to have some kind of awareness of the knowledge.
I was not inclined to comment. The magistrate allow it to pass as it is. Why didn't the magistrate objected at the very stage when the FIR came before him? So my point is that we all have to act. If we want to improve the system, all the stakeholders have to act.
A suggestion in that line is that I think the discretion should be done away with. It should be made a legal mandate that an offence is punishable up to at least 3 years or 5 years, where there is minor recovery, there should be no arrest at all. And the statement must be taken within 24 hours and the accused must be released by the police personnel themselves.
You're right, sir. In that conference, I suggested those amended sections in which I have recommended that up to 3 years, no arrest.
No arrest at all.
Under 160, you call him, interrogate him, question him, whatever you want to do, whatever recovery you want to make, do it, but no arrest up to 3 years. From 3 to 5 years, arrest with the permission of the superintendent of police. Yes. That at least he exercise some discretion. So we need to change. We need to change law as well as our mindset.
One is concerned, it's changing fast.
Question to Sugandha. These All India prison studies were for a few states, but is there any movement within prison departments to look at, capturing the state of their prisons? Like in Odisha, there was a court case.
Right.
Can you speak a little bit about the overall context?
So, in compliance to the Supreme Court in the Inhuman matter, as one of the, so Supreme Court had directed high courts to institute the suo motu matters in, particularly on prisons. So one was on general prison conditions. The other one was particularly in regard to deaths in custody, deaths in prisons. And so a lot of high courts have instituted those cases, and they have, these are, some are pending, some have been disposed of. We've also been tracking these cases from time to time. But yeah, the kind of, the energy or the intervention from the court that we see has only been there in very few states, like you mentioned, Odisha. So I think it depends on the interest of the Chief Justice or, the judge presiding that particular matter where, where there is an interest, then you can see that, they can actually haul up everyone and, some good orders are there. Karnataka is another example, where they have taken some of these issues seriously, and they have. But yeah, I mean, that is how, I mean, they've been monitoring, but the way we would expect them to monitor these issues, probably that needs to sort of be little more, done professionally. Yeah.
Thank you so much, ma'am. We are really sorry. Actually, we'll have to finish the next session by 3:50 or so that we can make arrangement as the High Court judge is already here. So we can discuss it later. I'm really sorry, ma'am. You're ready? Yeah, yeah. Shall I wait for a minute? Shall I start with the watch with me? Actually, we're on the website of the High Court. Right. So shall I start?
So now we'll be starting with the session 5 for the day, and the topic for discussion is death worthy, a mental health perspective of the death penalty. We have amongst us Ms. Maitri Mishra from Project 39A, who will be the presenter for the session, and the discussant for the section are Dr. Abhinandan Basi. And please, may we start, please?
Good afternoon, everyone. Just so that we can be a little bit up and about because it's the last session, I thought I'd play a small short animation video which captures the story of a death row prisoner that we had interviewed for this project and gives a sort of a bird's eye view of what the report is about. Can we have the video, please?
Voices aren't real, but for Dharmaketu, they are. He's a prisoner sentenced to death in one of India's prisons. These voices get so disturbing that Dharmaketu has attempted to die by suicide in prison. When he was 12, his parents took him to a traditional healer because they felt there was something wrong with his brain. It did not help. Dharmaketu dropped out of school and was violated physically and sexually as an adolescent. He was sexually abused multiple times by people in his neighborhood and in his workplace, people he trusted. He did not receive any formal treatment until he was incarcerated. Dharmaketu spent close to 15 years in prison, including over 6 years on death row, an experience that has caused him psychological distress, uncertainty about life and death. It was in prison that he was first properly treated for the voices. Dharmaketu was diagnosed with psychosis NOS, major depressive disorder, and intellectual disability. Dharmaketu isn't alone. 62.2% death row prisoners are diagnosed with at least one mental illness. 46 out of the 88 prisoners interviewed had been abused as children. 64 neglected, 46 had to drop out of school early, and 73 prisoners grew up in a disturbed family environment. And the mental agony of being on death row pushes them further.
We can come to the presentation now. Right. So before I begin, just a quick word about why this report is called Deathworthy. And the reason for naming it such was because through the qualitative interviews that we did with the prisoners, one of the most psychologically harmful things that the prisoners had to go through was this pronouncement of the death sentence, that effectively they were being told that they are better dead than alive. And to be told that you are going to be hanged till by your neck is a psychologically grueling experience that I don't think any of us have actually thought about. When we talk about the death sentence, we talk about theories of punishment, we talk about retribution and vengeance, but the person who's at the center of it, the person who's being sentenced to death, is often forgotten, and we often forget what it means to be told you need to die so that the rule of law can achieve its aims. So that's the title. And Professor Bajpayee isn't here, but he was the registrar at NLU Delhi when the report was conceptualized. So just to all the faculty here as well, the support of the university has been really, really sort of important for the report to have come out. And I think the NLU Delhi students were the main volunteers as well for the study. And it's because of them and on their backs that I'm here today. Yeah. Moving on. So I'd quickly just like to talk about what the population coverage. So we covered 5 states across the country. That was Delhi, Chhattisgarh, Madhya Pradesh, Karnataka, and Kerala. Other prisons where we sent, other states where we sent requests for permission, either denied or did not reply, and so we gave up. In total, we interviewed 88 death row prisoners and 110 families of death row prisoners across 7 states. The families of prisoners, death row prisoners in UP and Bihar were also interviewed because the interviews happened before we decided to drop those states. The methodology that we adopted for this study was a qualitative interview structure. We had qualitative interviews for both prisoners and families. And if you would like a copy of the report, it's on the website. But so the interview structures are in the report as well. The idea was very much to go in to look at the mental health of death row prisoners without having to rely on health records that they had in prison. Because as an empirical researcher, it wouldn't make sense to rely on already existing information and just end it at that, because many times, as Sugandha told us, prisons being overcrowded, they are not sufficiently equipped to be able to conduct mental health evaluations comprehensively for everyone. So the interview structure, interview schedule consisted of a qualitative interview which was both for the prisoners and the families. And with the prisoners specifically, we had psychometric tools. These are basically psychological tests that are validated across India's population, and they are used clinically to diagnose mental illnesses or other kinds of mental disorders. Right. So just quickly on the aims of the report. We started this report with 3 aims, and a lot of these have to do with what death penalty law in India currently is, which is that we have law which says that persons who are insane should not be executed. We have laws by the Supreme Court saying that mental and emotional agony of a death row prisoner matters, and that after a certain period of time, you can't execute them because of this mental and emotional agony. And the aim on intellectual disability was being done to fix a gap in the law. Intellectual disability, I'll come to that later, is a mental disorder, and it speaks very closely to issues of whether a person deserves the death sentence or not, or whether a death sentence is warranted in a certain case. But there is no law in India currently where judges can be guided on what to do if a person has intellectual disability. The law being unclear, we thought it was a good idea to look at this. Do we have prisoners with intellectual disability among us? And as I'll take you to it later, yes, we do. um, right. So all of these aims that you see are related to mental health. They are illness, health, disorders. But what we realized was that you can't conduct a study like this where you're looking at mental health without actually doing a longitudinal history of who they are, who they have been, what kind of lives they have led. And that led us to understanding the very specific vulnerabilities and social realities of death row prisoners. We know that 74.1% of death row prisoners come from socioeconomically marginalized backgrounds. But what we wanted to explore here was, what does being socioeconomically marginalized mean for them? How does that experience translate, or how does that fact translate into experiences? And we looked at something called as adverse childhood experiences. Now, adverse childhood experiences is a technical term in the field of mental health, and these refer to uh, interrelated negative experiences that children go through as they are growing up. They're important because the presence of adverse childhood experiences without any positive factor in a child's life is very often related to violence and violence and poor health later in life. Um, what we found was that 73 prisoners were exposed to 3 or more adverse childhood experiences. And that figure of 3 or more is important because what is known as a dose response relationship. So, with each increasing number of adverse childhood experiences, the likelihood of violent behavior later in life or health problems later in life continues to increase. But one thing to see is also that these adverse childhood experiences don't operate in silo. They are interrelated and they often lead to other adverse childhood experiences. For instance, we found that 46 prisoners had endured childhood abuse, that is, abuse either physical, sexual, or emotional before when they were growing up. And 46 out of these and a large number of these 46 prisoners had to undertake adult responsibilities as a child. What that means is that when one way to look at this or to interpret this data is that either adult responsibilities are such that they amount to childhood abuse, or that childhood abuse might be leading to prisoners leaving home, running away from home, and trying to earn a living on their own. For instance, you will see that 22 out of these 46 prisoners did run away from home, right? So you can see that there is a clear link between one experience leading to multiple negative experiences. The other example I would like to give is that of childhood neglect. Now, neglect is understood as either emotional or physical or financial neglect given or neglect by a caregiver of a child's need. One thing to remember is that these are not factors, or childhood neglect is not necessarily something that the parent thinks and does. A lot of these prisoners were came from very, very poor background. So childhood neglect becomes almost a reality of their lives, whether they want it or not. But what childhood neglect can often do is to lead children to go and hang out with people who might not have positive influences on them, what are known as deviant peers. So as you can see, 50 out of the 63 prisoners who had faced childhood neglect also were exposed to deviant peers. What that also means is that you are unlikely to have low education or unlikely to attain higher education. And what we found was 41 out of these 63 prisoners did have low educational attainment, and we defined it at education less than 8th grade. I'm not saying, and this figure does not mean that low education is necessarily an outcome of childhood neglect. It is often an outcome of poverty as well, as we saw with both Deathworthy as well as a previous report, the Death Penalty India report. Another interesting thing is a factor, adverse childhood experience that leads to multiple adverse childhood experiences is a disturbed family environment. A disturbed family environment is defined as an environment where the child is not feeling safe. It could be for reasons of domestic violence. It could be for reasons of financial adversities. It could be because there is sort of nobody in the home there to take care of the child. And what we found was that when a child came from a disturbed family environment, it was highly likely that they were taking on the role of the adult, either to their siblings or to earn money independently for the family. They were also very, very likely to hang out with people who will not have a good influence on them. And very worryingly, we also saw a large majority of them taking to substance use at a very young age. Early onset of substance use is defined as using substances, whether it's alcohol, cigarette, cannabis, or any of those substances below the age of 18. And what early onset of substance use often does is to create an addiction. It is also then going to lead to various other problems in a person's life. And we must understand that the early onset of substance use or substance use at this age is not necessarily a wish that the person has. Often it is done under peer pressure. Often it is done because you have entered adult working spaces where the adults are smoking or drinking. And so now you need to be able to act like them. Another thing that we looked at was traumatic life events. Again, much like adverse childhood experiences, these events also have a relationship with poor mental health later in life. And we found that almost all of the prisoners we interviewed had been exposed to one traumatic life event. But 58 out of I think 56 death row prisoners were exposed to 3 or more traumatic events. Now, what traumatic events do to you is to lower your resilience to negative effects later on in life. We've already seen that these prisoners come from extremely vulnerable backgrounds. On top of that, they have faced traumatic life events. And when they get the death sentence, it is not a surprise that there will be something which breaks them because they're already built on a foundation which is not very strong. Now I come to the first aim of the study, which was to look at psychiatric concerns on death row. The graph that you see on the screen is just mentions the risk of certain mental illnesses as they came out on one of our psychometric tools. In terms of actual illnesses, we found that 62.2% of the prisoners, of the 88 prisoners we interviewed, were diagnosed with at least one mental illness. Major depressive disorder, generalized anxiety disorder, and substance use disorders were the 3 most common mental illnesses. But so was suicide, as well as psychosis or schizophrenia. There were 6 prisoners who were at risk of schizophrenia. 2 of them had had an onset in prison and one of them had an onset while they were in solitary confinement. Now, why these figures might look like something really obvious, why it is important to look at them is because in context, you have to see these numbers in context. If you compare our data, the death-worthy data with the community population, you see a massive and worrying increase in how ill our death row population is. You have 35% of the prisoners having major depressive disorder when less than 3% have depression in the community population. Uh, Similar with anxiety. Substance use disorder, you'll see, is a little less in the death row population than the community population. And that too is worrying because substances are contraband in prison. So even while in prison and on further restriction being on death row, if they're using substances, it should worry us because often substances, and we'll come to that later, often substances are a way to self-medicate various other mental illnesses. This is just a graph to indicate that while there's an overlapping of mental health concern. It is not that one person has depression only. As you can see, 34 prisoners had more than one mental illness. Often depression and anxiety overlapped. There were other kinds of illnesses which was overlapping. Why it is important to understand this overlapping data is because it has consequences for treatment decisions. It also has consequences for how you're going to cope with prison life, not just prison life, a life on death row. Now, this study for the first time, if I'm not mistaken, anywhere in the world, tries to look at what relationship does being on death row have with mental illness. So we tried to look at risk factors, and we did find that there were four broad areas. These have all been defined by us, and the qualitative interviews were coded accordingly. But social isolation, violence, either from other prisoners or by prison authorities, um, had a positive correlation with either a mental illness or the risk of mental illness. Lack of work was interesting because, and an important aspect for us to look into. So prisons are regulated by prison manuals in each state, and prison manuals often prohibit death row prisoners from either working or from engaging in education. Now, what that does is you're spending your entire time in prison doing nothing and thinking about the fact that you are on death row, thinking about death, thinking about your family who is now absolutely stigmatized, often is not coming to meet you because of lack of finances. So this lack of engagement in prison creates a certain quagmire where these dark thoughts take place and you can't really do much about it. And this is important because this is despite a ruling from the Supreme Court saying death row prisoners must be allowed to work and engage in prison. But in our experience in representing death row prisoners, we found that that does not happen. Differential treatment we defined as being treated differently either by the inmates or by prison authority because you're on death row. By law, death row prisoners should not be differentiated from other prison population because they're not considered death row prisoners under current law unless their mercy petition is rejected. But what we found was they were very much treated like death row prisoners from the moment that they were sentenced to death. Um, and that is also the we placed primacy to that experience of being treated differently. I just wanted to take everyone through these correlations that we drew. Correlations are essentially statistical ways of matching one factor to the other to see if there is any relationship between one factor that you want to analyze and a risk factor. This was with a 90% confidence interval rather than the 95%, but that is still an accepted confidence interval in statistical analysis. And we found, like I had just mentioned, violence by prison authorities, harassment by other prisoners, barriers to communication with family all had a positive correlation with depression, anxiety, or substance use disorder. Coming to negative correlation, as you can see, people who were not working or were not allowed to, or were allowed to work, they had a negative correlation with depression and anxiety, which means that prisoners who were being allowed to work were less likely to be at risk of depression and anxiety. Um, Time spent in prison and on death row was an interesting finding for us. Essentially, what we found was that the longer the person stays in prison, the less likely it is that they will have depression and anxiety. And this is actually not surprising to prison researchers, because what prison researchers for the longest time have been finding that prisoners tend to, they start adjusting to prison, which is not to say again that they are doing well in prison. It is only to say that what we would consider bad experiences, psychological harm, for them has been so deeply internalized that it does not affect them anymore. They don't, or they think it's not affecting them anymore. Now coming to the second aim, which was on intellectual disability. So, like I said, there is no law in India on how the death penalty is to be treated for persons with intellectual disability. However, internationally, there is a prohibition on imposition of the death sentence on persons with intellectual disability. The reason is that they've been found to be at special risk of wrongful execution because of certain characteristics of the disability itself. Without support, without their needs being fulfilled, persons with intellectual disability can be extremely gullible to false confessions. They can also be extremely gullible to actually doing the most risky part of a crime. They can be easily influenced. And so often we find that persons with intellectual disability end up doing crimes or engaging in violent behavior or crimes without actually understanding the full extent of what it is that they are doing, or understanding whether what they are doing is risky or not, and more importantly, why. And intellectual disability, therefore, goes at the very, very heart of death penalty sentencing, which essentially is whether you deserve the death sentence, whether what you have done is so bad that you are extremely culpable and therefore must be given the death penalty. What we found was that 9 out of 83 prisoners, 11%, were diagnosed with intellectual disability. Why this figure is stark is because for none of these 9 was the intellectual disability ever brought before court. And that tells us the state of death penalty sentencing in India. It also speaks to how broken our criminal justice system is. We've been having conversations whether prison is responsible or police is responsible. And I think what we need to address and understand is that the whole system is responsible and broken. And fixing one is not going to help much. There needs to be a certain overhaul, which we are not wanting to do. Over 75% of the prisoners had deficits in intellectual functioning, which also makes them vulnerable. By the way, if anybody has a question on what is intellectual disability, please let me know and I'll answer. I don't want to go into that right now. Now, the figure 11% doesn't look very stark in itself, but when you compare it to community population, in the community, there is only 0.6% prevalence of intellectual disability. In the death row population, it is many, many, many times higher. And this is not to say because death row prisoners or persons with intellectual disability are more dangerous. It is because, like I said, they are more vulnerable. They are vulnerable to giving false confessions. They are vulnerable to being misunderstood. They are vulnerable to not being able to give proper legal instructions to the counsel. And so all of these factors are at play when a person with intellectual disability enters the criminal justice system. The third thing that we looked at was something that we called the pains of death row. This was a phrase we borrowed from a very famous study by a criminologist called Gresham Sykes. He coined the phrase pains of imprisonment. And pains of imprisonment essentially refers to certain deprivations that prisoners go through, material and psychological deprivations, as a result of which there is a certain psychological pain and a blow to a person's personality and sense of worth. there were multiple factors that we found that were responsible or contributed to the pains of death row. One was the trauma of being sentenced to death, that is, the trauma of being held death worthy. This trauma is also magnified because we all know how death row prisoners are spoken about in the media. They are vilified, they are demonized, we hate them, yet we know very, very little about them. There is not much information that we have in the media when we, as consumers of media, when a death row prisoner is showed the way in which they are showed. It's also traumatic because very often those narratives are finding their way into legal judgments as well as inside prison. So overall, the starting journey of a death row prisoner is that they know that they are hated, they are reviled, that their families are in danger, that their life is in danger. That is the starting point of when you sentence somebody to death. I've already spoken about the indignity and vilification that death row prisoners go through purely because they are death row prisoners. For instance, in one of the interviews, while we were having the interview, there was a prison official who just passed by and pointed to the interviewee and started saying "Phansi, Phansi." And we asked what that was about. And he said that this is how they refer to him. They refer to him as Phansi because he's on death row. In another instance of these very micro humiliations was the fact that when we went for interviews, prisoners were not allowed to sit on chairs. This was a way to show them down. They were not allowed to have tea at the same time that we were having tea. So there are very small indignities which are on a daily basis that are inflicted on death row prisoners because they've been given the death penalty. One of those is powerlessness. And when I mean powerlessness, what I mean is the feeling that they go through when all of their experiences are delegitimized. And they are already, you are suspecting whether they are telling the truth or not because they are death row prisoners. So when, for instance, when we went to interview them, we were told by superintendents and jailers, don't believe them, they are death row prisoners. We were told, don't, of course they are going to lie because they are death row prisoners. And the problem with these kinds of statements is that you are negating the entire existence and experience of a person, which goes to the heart of dignity. It also, of course, speaks to how unfamiliar people are with research methods. When we do our qualitative interviews, it's not all an analysis. We don't take their word as is. We do cross-check with other data. But I wanted to just speak to this powerlessness a little bit. The apprehension of execution. So when a prisoner is being sentenced to death, from the very moment, they are now thinking every second or every day that comes now is going to decide their fate, whether they are going to live or die. The Supreme Court in its jurisprudence has limited this to when their mercy petition is pending. What we found was actually that that apprehension is there from the moment they are sentenced at the time of appeal. Every single day, when in some of the cases when we were interviewing the prisoners, they thought that they were being taken out to be executed. That is the level of apprehension that they have, that anybody who comes to meet them, their first thought is, it must be because I'm going to be executed. A little bit about the missteps of the death penalty. We also came across prisoners against whom death warrants had been executed. Well, they had been issued by the trial court. And death warrant basically means now you're going to die. Within 15 days, that's it. In one of the cases, well, actually in two of the cases, but I'll narrate the story of one. The warrant had been executed. The person had had his last meeting with the mother, and then the warrant was vacated. This is what it means to be on the death penalty, and this is why we say death is different. Such kinds of lapses of the law are not life and death decisions when it comes to life imprisonment or other kinds of imprisonment. But with the death penalty, any small misstep brings death one step closer. I'd also like to talk about a little bit about self-harm and suicide. It should be no surprise to us that a lot of death row prisoners, because of the psychological pain of being on death row, do harm themselves, do attempt suicide, and unfortunately, many of them are looked at as criminals. In their history sheet in the prison, it's going to go as an offense rather than as a event that needs care and treatment response. It's seen as something that they are doing to as an offense. Um, Death row distress is clear enough. This is something we defined as the distress of being sentenced to death and living on death row. And we found that 94.1% of prisoners who said that they were experiencing death row distress also had attempted suicide. So you can start seeing very, very close link between the fact of the death penalty and certain outcomes that a justice system should not be having. Quickly, some data on acquittals and commutations. By the time this report was released in October 2021, 19 prisoners had been acquitted, 33 had been commuted, and one had been executed. What that means is more than half the time, our lower judiciary is getting it absolutely wrong as to who deserves the death sentence. What are the consequences of this? We might think that great, our justice system has corrected itself because at appellate, these persons have either been acquitted or commuted. But the fact is that many of them are leaving prison with the scars of being on death row. They have depression, they have anxiety, they have attempted to harm themselves, some have PTSD, some have cognitive impairment. Their lives have completely changed, and we might celebrate it as a rectification of justice, but to them, they are leaving prison as broken individuals, and we need to reflect on what is breaking them and who is responsible for that. I just want to talk about quickly two developments that happened post-Deathworthy. One was in a recent case of the Supreme Court in Manoj and others versus State of Madhya Pradesh, where the court said and recognized. So this is a case where we represented the three accused that were there before the Supreme Court, that the criminal is not a product of only their decisions, but also a product of the society and states failing. And this is an absolutely crucial recognition by the Supreme Court that when we look at individuals who commit crimes, we cannot look at them as just individuals. They are a product, and we should bear some responsibility for that. In this report, in this case, the Supreme Court also mandated psychological and psychiatric evaluations to be submitted to the trial court before sentencing, and a certificate from prison authorities on the conduct of the person in prison. These are all massive changes to death penalty sentencing, because earlier it was much more free-handed and you death sentences being given arbitrarily. The court has also expanded what can be considered as factors regarding the criminal, the mitigating factors that courts need to look at, to include things like adverse childhood experiences that is being reflected as early family backgrounds. And something that just happened was the Supreme, in one of the applications we had filed for mitigator access, the Supreme Court took it up and instituted a suo motu petition. It's a fantastic title of the writ. It's called Framing Guidelines Regarding Potential Mitigating Circumstances to be Considered While Imposing Death Sentences. So this suo motu proceedings was, this is Justice Lalit's doing, and his idea was to lay down mitigation guidelines to institutionalize and be available to prisoners who are at risk of death sentence from trial court onwards. The judgment is reserved currently. It is likely to be referred to a constitutional bench on whether this practice that the court wants to institutionalize is incompatible with the current law on the fact that death row prisoners can be sentenced on the same day as they are convicted. Yeah, with that, thank you very much. I think I overshot my time, so I apologize for that.
Thank you so much, Maitri, for this initiative and for this discussion that you just, you put the ball rolling. Thank you so much for this initiation. Is there any question from the audience? In case there's any observation that you wish to make or any questions, please. If there are none, then I have few. if you are sure, not too occupied with that. First of all, I need to understand that how do we, or like what do we do to create awareness for identifying intellectual disabilities in, under trials or people who are on trial? Are there any significant symptoms that we should look for? Or like, how do we incorporate these things?
Right. So intellectual disability is notoriously difficult to diagnose because most of the prisoners who get involved in the criminal justice system or their trials are going on would have mild or moderate intellectual disability. What that means is that they appear very much like you and me. They appear like they are coping. They appear like they can do things because they have learned to what is known as mask. And so it's very difficult to diagnose. And what that requires for us to have a fair justice system requires that it's not just lawyers and judges who are part of the justice system, but caregivers, social workers, psychologists, psychiatrists who are attached to the legal system to be able to assist judges and lawyers to identify whether there are persons who have special needs. Because trying somebody who has an intellectual disability is also a violation of their rights under the Rights of Persons with Disability Act. But so it requires the system to expand itself to understand the fact that you and I might not be able to understand intellectual disability, but a psychologist will probably do. And so those people need to be brought within the fold of, I think, the criminal justice system to make sure that this doesn't happen as frequently as it does.
But then we have, we have these legal instances where we talk about rarest of rare cases where, death or capital punishment has to be accorded. So we are not equipped to look for these nuances when we talk about, these psychological or psychometric nuances which have to be there. But then we do not have a scope to incorporate them also. So where are we looking for a breakthrough?
Right. So I think you've raised a very important question, and that's something that I grappled with a lot, which is that you are sentencing somebody to death, but you actually have no means at your disposal to recognize whether there's somebody who deserves to be sentenced to death. There's this one case of the 70s, Santa Singh versus State of Punjab, where Justice Bhagwati points that out, that judges and lawyers are not equipped. It has to be people from the social sciences. So one of the things that might happen with the mitigation guidelines that Justice Lalit might institutionalize is that in at least capital defense, along with the lawyer, you have what we call a mitigation investigator, which is a person trained in social sciences, is a social worker, who will then talk to the prisoner, to the family, to people who know about this person, and then bring out mitigating factors before the court. So things like that, that kind of change and revolution is absolutely essential in a justice system which thinks it's fit to sentence people to death.
One question. Involvement of social worker on the point of giving punishment, when that will be started? We are having this death penalty in the 302 cases. While we are convicting a person, the judge doesn't know that what punishment is going to be given, because that punishment is only on the basis of depravity of the offenses, like in the Nirbhaya case. So how much depravity of that offense is that? If the social workers, all these persons are to be engaged, meaning thereby after conviction and before sentence.
Yes.
How much time will it take after conviction and before giving any order on punishment? Is there any?
Right, sir. So just one correction to that, which is that the death penalty is not to be given on the basis of depravity of offense. The law is that you have to look at the criminal as well. That you have to look at where the criminal is coming from. As I said, in Manoj, the court has expanded what needs to be looked at. So there was a law commission report on the death penalty earlier, not the latest one, which...
Mitigating and
So can I just complete? Which said that 14 days can be perhaps given between conviction and sentencing. We are hoping that Justice Lalit will resolve this issue as to is there a need to give extended time or how much time should be given there. It is also that under Manoj and others, the court has now put the responsibility on the state. The state has to start collecting evidence which pertains to psychological and psychiatric reports, jail conduct report, as well as all of those mitigating circumstances. The state can start doing it at any point, but the judge can only know it after they have convicted.
Because engagement of these stakeholders is only after convicting the person
Right. Yeah.
in these offenses.
Absolutely.
When you talk about these impacts, how much are they impacting the rationality of an individual? Because we're looking at a 35% bracket of prisoners who have these disabilities. I'm using the word disability not in the right light. No, I
Right.
Ji. So, is it really impacting the rationality here? Because see, we are looking at the impacts here. We are looking at the assessment of death row prisoners and what they go through, be it the disrespect or be it the neglect or be it the, that trauma of dying every single day till the time that they actually die. So what is the impact of rationality? Like, do these illnesses create an impact on rationality? Or how important are they when we are assessing a criminal or an accused?
So I think there are two things to look at there. One is that if the person is already on death row and going through these experiences, I think what we need to start thinking is that what the death penalty was meant to do? Was it meant to create a mental health crisis on death row? And I think the answer is no. So I think we need to understand that the purpose of the death penalty was not to make sure that there are persons with mental illness or that persons develop a mental illness. In terms of rationality, I think I'd like to answer your question from a disability perspective, which is that might come into play at the time you're assessing whether the person was, how culpable was the person when they were committing the offense, right? And maybe I wouldn't use the word rationality because I think all of us are rational and irrational at various points in our life and in a day. Right. So what I would like to say is that these disabilities do affect the way the person makes sense of the world and then responds to them. So for instance, with persons with intellectual disability, it's very frequent that when they are unable to communicate or when the samne wala is not being able to understand, they will start throwing things. And that looks like they are getting angry and behaving disrespectfully, but it's just a barrier that they can't communicate. So it is about how you respond to the world that affects, that the disability affects.
Okay.
Speaking about the parameters last time when we had this colloquium, so we were looking at these administrative parameters which talk about legality and which talk about the impact on the delivery of justice within these criminal justice system.
Right.
Do we include these psychometric parameters now? Do you think it is important? It is the time now that we
Is the
start
question
including
me?
them? Yes, to the team. Like, do you think the state has to acknowledge this as a parameter? Because we were looking at legal aid, we were looking at police reforms,
Yes,
we were looking at how the administrative responses are towards the people. Because when you look at the report, there are different parameters that we picked up, ma'am. My question to this gathering or this August gathering is it the time now that we start accepting or that we start telling the state that these influences or these parameters they need to be included within these pillars?
Okay, I think these are very subjective because it was discussed that intellectual disability is very difficult to diagnose. So if something is very difficult to diagnose, how can it be proved as a mitigating factor before the court?
So I would flip the question to you, and I would say if there's something that the system can't do, then should the system be sentencing that person to death, right? If you can't diagnose, if the system doesn't have the capacity to diagnose intellectual disability, then it should not have the death sentence, would be my response. Not that it can't be proved, because it can be proved. But does the system have the capacity to get a psychologist and ensure that before they sentence somebody to death, the trial court is getting that person diagnosed for mental health concerns?
It can be the other way that if something cannot be diagnosed, whether it should be a factor to be considered.
It can be diagnosed. That's what I'm informing you that it can, we did diagnose, right? We diagnosed 9 out of 83 persons with intellectual disability. It can be done. Does the system want to do it, is the question. And can the system do it? And if it can't, then what should be the solution?
I think Maya is going to answer that. Please allow me to ask my question. Yeah, I would just want to ask my question because it's very rare that we talk about death penalty and that to mental health of death row prisoners. Because you interviewed them so intensively, did you come across any CCL cases among this sample? They were in institutions. Is there any childhood history that can be shown in terms of institutional care or lack of it?
Lack of care, in the sense that there were prisoners who would have benefited if they were in care. But like I said, they also come from extremely backward areas where the state hasn't actually reached and where its services probably haven't reached. So
Juvenile offenses, any history like that?
no. So one of the things we were very clear about was that in this interview, we are not going to ask them about offenses because that one puts them off because you're again, why would they speak to you if you're going to speak about the same thing? And the second was that we did ask about prior, we didn't put it as offense, we put it as violence in earlier in life. Some people admitted to sort of having scuffles and brawls and things like that, but no criminal complaint registered against any of them. And that is also extremely common because we know that a large majority of persons who get the death sentence are first time offenders.
Thank you, ma'am. Thank you so much. So I think we are through it. So
thank you.
Thank you, everyone. So we'll be starting with the valedictory session within the next 15 minutes.
Thank you. We'll start the valedictory next 10 minutes. We'll just clean the area. And we request you to please fill the feedback forms till then. And thank you so much. कितने लोग हैं? I welcome you all to the valedictory session of International Colloquium on Criminal Justice in Numbers, organized by Center for Criminology, Criminal Justice and Victimology at RGNUL, in collaboration with India Justice Report. I extend a warm welcome to Honorable Mr. Justice A.G. Masih, Judge, Punjab and Haryana High Court, Mr. Tarseem Mangla, District and Session Judge Patiala, Mr. Amit, CJM Patiala, Professor G.S. Bajpai, Vice Chancellor RGNUL, Professor Anand Pawar, Registrar RGNUL, Ms. Maya Daruwala, Chief Editor, India Justice Report, and I also welcome the participants representing different organizations, members of the judiciary, faculty from RGNUL, and my dear students. So Pythagoras has rightly said that numbers have a way of taking a man by the hand and leading him down the path of reason. In these 2 days, sir, we discussed that how the numbers are relevant in a criminal justice system. Without taking much time, I now invite my faculty member, Mr. Ankit Kaushik, to please present the report of the event. So please.
Thank you, ma'am. So, over 12 sessions in the past 2 days, all of us have been engaged in the task of understanding how empirical legal research is now paving the way for evidence-based policy and legal decision-making within our criminal justice systems. This colloquium is a collaboration between the India Justice Report and the Rajiv Gandhi National University of Law in an effort to map the growth of empirical legal research in the field of criminal justice in the Indian context and to showcase the potential of data as a driver for the development of holistic policies and laws. I would say that we have been largely successful in this endeavor. At the inaugural session, we had a welcome address by Professor Dr. G.S. Bajpai, who reminded us that data-driven research in the field of criminal law maximizes the objectivity and scientificity in the criminal justice system. This was followed by the inaugural address by Ms. Maya Daruwala, Chief Editor and Convener of the India Justice Report, who told us that the purpose behind having an India Justice Report is to spark a debate on the criminal justice system based on facts and numbers. We also had Ms. Sakshi Sahni, the Deputy Collector of Patiala, who gave her inaugural address and spoke to us about the criminal justice system from the perspective of a policymaker and drew a comparison between the present-day criminal justice system and the fictional city of Gotham. In the first session, we had Ms. Mita Dutt, who spoke to us about what judicial data tells us about criminal trials. She also mentioned and presented the Daksh report, which takes into account median days for disposal by case categories and grouping of case types by complexity of subject matter, procedure, and multiplicity of actors. The second session was by Mr. Sudhir Mittal, who was the director and officer in charge of the National Judicial Data Grid, and he gave us an overview of the needs, benefits, and challenges of the National Judicial Data Grid. The third session was by the Indian Police Foundation. We had with us Mr. N. Ramachandran and Mr. Sanjay Vashisht, who spoke to us about measuring citizen satisfaction of the quality of law enforcement and measuring the level of public trust in the police. The fourth session of day one was by Mr. Vinay Kumar Pandey and Ms. Divya Singh. Mr. Vinay Kumar Pandey is the Chief Statistical Officer of the National Crime Records Bureau. He gave us an overview of the methodology which has been adopted by the National Crime Records Bureau in coming up with the Crime in India Statistics Report and the Prison Statistics India Report. The final session of day one was by Ms. Neha Sinha from Artha Global, who talked to us about evidence-informed approach to policing in India and how data can inform diagnostics and implementation. The first session today was by Ms. Erindra Gonzalez of the World Justice Project, who told us about the Rule of Law Index in Mexico. She told us about how this has come to be developed and how this is now presenting more or less a state of the rule of law across the world itself as well. The second session was by Ms. Apurva from the Vidhi Center of Legal Policy, and she gave us insights from judicial data with respect to the impact and implementation of the POCSO Act. The third presentation was by Mr. Sunil Chauhan, who spoke to us about quantifying barriers to access to justice. The fourth session of today was by Ms. Radhika Jha from Common Cause, who spoke to us about police advocacy, performance, and perceptions, narratives by numbers. We also had a session by Ms. Sugandha Mathur, Commonwealth Human Rights Initiative, who told us about prison reforms and using data to identify key issues and solutions. The final session for today, session 6, was by Ms. Maitri Mishra from Project 39A, who presented her report titled Death Worthy, a mental health perspective of the death penalty. This report raises pertinent questions about our criminal justice system's ability to accurately determine a person's deathworthiness, and it focuses on social reality of prisoners, and it indicates that an overwhelming majority of prisoners suffer from abuse, neglect, not just at home, but also at the hands of the state and society. Um, that was a brief of what we have done over the past 2 days. Thank you.
Thank you very much, sir. I now invite our worthy Vice Chancellor, Professor Dr. G.S. Vajpayee, to please address the gathering. Sir, please.
Honorable Justice A.T. Masih, Mr. Tarsi Manglaji, District and Session Judge, Patiala Court, Mr. Amit, CJM, Patiala, Ms. Maya Daruwala ji, all learned participants, presenters, resource persons to this 2 days international colloquium. It is my duty to very briefly reflect upon the fact that the idea of this colloquium emerged during our interaction with the team India Justice Report a couple of months back, where we were contemplating to understand the manner and the extent to which the data can be utilized for the purpose of decision making by the public functionaries, especially in the context of criminal justice system. And therefore, we were thinking of the fact that the real utilization of such data can be enhanced if it becomes amenable to be used by the end users in different organs of the criminal justice system. We thought that let us sort of plan an opportunity or a platform where all the data makers and data generators could come together to share their ideas and their experiences of creating these data sets. As we were thinking, we actually proceeded with this idea that there is a huge gap between data creation and data utilization for the purpose of policy evaluation, policy rectification, and especially in the context of criminal justice system. And therefore, this opportunity produced this gathering where as many as more than 24 people representing different organizations assembled here in last 2 days to make a variety of presentations which were scrutinized, debated, and discussed in the context of the core aim of this colloquium. So I thank you for all your. There are some important takeaways. The first thing to which we agreed, and rather it was my core idea which prompted me to sort of conceptualize this. I said that a thing which can't be measured does not exist. So I said that if we want to have evidence-driven decision making by the police, by the prosecution, by the court, some amount of measurement is needed, measurement of performance. Because if you look at the Western world, they are measuring almost everything, every decision making, not criminal justice system as a whole, whether they are the decisions relating to arrest, bail, sentencing, parole, probation, everything. So they have access to justice even was measured. So I'm thinking that in this 21st century where we are about to have a data protection bill, we are about to have a lot of other initiatives, and there are already initiatives like National Judicial Data Grid and all those things. But probably this can be an opportunity to plug those loopholes which can otherwise become very vital in terms of enhancing the performance of these subsystems of criminal justice. And in the end, as the report was presented, there are some important takeaways and there are some important questions. In important takeaways, we could identify the problems with the existing data sets. We are creating a document which will be given to all the organization to revisit their practices of data compilation. And we also could identify the ways and uses of the manner in which these data sets exist. And we also could, see the coordination and sharing of these data is very important, because sometimes one organization is creating the data, other organization is creating a different data set. Both the organizations are never in touch. So like, for instance, I said that if the crime in India data is being compiled, but there is another data set which have the data on family, socioeconomic profile of that district, development profile. Development profile is very crucial from the viewpoint of criminal justice data. But these two sets will never come together, where there are two organizations who are very independently working without having any iota of coordination. So essentially, this need of coordination was felt very well, because we think that we are in isolation creating a data set which is useful. But contextually, it can become more useful if it is contrasted by other kinds of data. So this confluence we were actually came out with quite prominently, and we have stressed upon the fact that there should be a data-based conceptualization of justice. This is very important. Data-based justice is always experienced, not sort of seen in measurable terms. So my perspective of, so all the stakeholders have different perspective of justice, access to justice, then reduction of gap of data makers and data users, I have already said. But there are certain questions which emerged during this, colloquium, which very briefly in 2 minutes I'll say, and then probably we can move on to look at. So first was why data and research did not impact enough as far as criminal justice decisions are concerned. So probably one reason is that data literacy and data visualization on the part of user is not very remarkable. So you need a minimum degree of competency to read and utilize that data. Now the question is, who would fill this gap? So probably there is a need to stress the fact that while these organizations are working on their chartered functions, there has to be an institutional arrangement which should inform or which should facilitate the better utilization of the data by these functionaries, because they have their own core functions. And how often the data are put to use in raising the efficiency of criminal justice administration. So data is existing, but that data in isolation, criminal justice users are not using. Second, so like, for instance, if there is a pendency in the court, is there any data set or is there any empirical assessment of the situation can actually help a district court to raise the level of performance of the court to be able to dispose the cases in a faster way? What matters, what does not matter, judge may not be in a position to understand. It is for the researchers and other stakeholders to inform. As I've said in the first day, that a myth was broken by research that if you raise the number of manpower, there would be an increase in the disposal of cases. It not necessarily happened, but it was. So there are several myths which we take as true. However, we do not have any empirical backing to understand as to whether they exist in reality or not. That is another thing. So can impact study is another thing, because several things are happening, but in terms of impact study, but who will do the impact study? Because I always say we cannot leave these things to the core functionary. There has to be a separate wing to take care of such things. What kind of data sets are required to facilitate the efficient, judicial administration, for instance? Again, that information is there. Another paper I was reading very recently, which is talking about something very, very important, and that was regarding the text mining. So they are saying mostly the nature of, for instance, the judicial decision, adjudication matters, they are textual in nature. Can there any way, because the decisions are written in text, if you want to accelerate the judicial disposition, you need to analyze the text or text mining and can create a data analytics. This big data business is into it now this. So can the big data applications or data analytics application do the enough levels of text mining to be able to come out with those kinds of solutions which are so urgently needed in our context now? So how it is important to know that how the targeted beneficiaries are experiencing. Suppose cases are decided, as I mentioned, the Supreme Court decision, they are not reaching to the how the targeted beneficiary or end users are getting impacted. So lawyers, researchers are celebrating that a judgment has come, but the state of affairs don't change for the people whom actually that judgment matters a lot. So this follow-up study can provide and give very good input to the courts that these are the gap areas in which the things are not moving from the executive side, and follow-up actions can then be taken. So this is my understanding on so many issues which we have. I'm sure that the findings which have emerged from this colloquium will go in a very long way in terms of setting up the tone for core and very rigorous empirical legal research, because that precision is needed. General things we know, but for the functionaries, you need to be very, very precise. I am at this moment I am particularly delighted today the gracious presence of honorable judges here, and his guidance. I had a very fruitful, pre-valedictory session conversation with him, and it was a sheer delight for me. And he assured all help and all guidance to this university. That I can very briefly say that whatever measures in last 1 year we have taken in terms of promoting a culture of research, a culture of publication. As a result, we have now more than 45 teachers. There used to be 30 teachers only. So our ratio, student-teacher ratio has been significantly improved now. Besides that, we have started appointing dedicated research associates to take care of projects. We have recently been awarded as many as 4 or 5 very important research projects by different agencies. And besides that, the National Commission of Women, National Human Rights Commission, they have given us several assignments, including the Ministry of Consumer Affairs. So these things and these, developments do now provide a very vibrant culture to these students to participate in the activities of such kind, whereby we intend to make a very academic intensive institution, what is the core aim of this thing. Today, sir, I'm very glad to have you again, and my heartiest welcome. And I also welcome Sachinja Sahab and CJM. Thank you so much for your presence here. Thank you, one and all.
Thank you very much, sir, for your input. I now invite Ms. Maja Daruwala, Chief Editor, India Justice Report, to please address the gathering. Ma'am, please.
Thank you. Sorry. Well, thank you very much for the opportunity. And we at the India Justice Report, I'm not sure whether, I know that my colleagues here are all aware of it, but Justice, I'm not sure whether you are. But it basically looks at the capacity of 4 pillars of the justice system: police, prisons, legal aid, and judiciary, and looks and sees whether their budgets are adequate, their manpower is adequate, their infrastructure is adequate, whether they are diverse enough, and what is their workload, and how, what are the trends over years. Now, while doing this work, we have come across gaps in the data. We've now become much more capable because of the NJDG and the state level data grids that have come about. And we see that this is improving all the time. But as we watch, as the Vice Chancellor has said, it's the welcome for these kinds of studies to go to the user, or who would be the police, the prisons, the legal aid authorities, and the judiciary, and to have dialogue with them I think that is a great deal of missing link still. Um, and I do see the contribution of civil society here in this being much more enhanced were there a greater welcome for it. Because the functionaries of the justice system are way too busy, way too steeped in just the administration of their work every day. The burden is huge. Everybody recognizes that. But I think the thing that I would very much like recognized about the work that people like me do is that we are very fine advocates for the people who are working the justice system and not critics of them, because the data doesn't allow us to be critics. We don't draw deep conclusions from looking at capacity or even the common causes work, survey work, if I may take that, or the work on death penalty. It draws very valuable conclusions where it does, as the death penalty one does. But in the case of, let's say, the common cause one, where they looked at what are the prejudices and the attitudes and the perceptions of the public toward the police, but of the police toward the public. They don't draw conclusions and say, well, this is bad, this is good. They say, well, here are the numbers. Take a look at it. That's similar with the India Justice Report. We are on our third report. And it's only now that we're beginning to tentatively even suggest recommendations. And one of the recommendations, of course, is that there should be much more dialogue between these kinds of studies, which we spend our lives on, and your work. That's one. And the other one is to very much look at these studies, which are many of them very rudimentary and initial in nature, and localize them. You know, give you an example. For instance, if we say pendency in X court is very high, last year it was even higher, and this year it's going to be even higher, is the time when I would expect someone to come in and say, look, you're right about the pendency, but 9/10 of the pendency is because a witness has not turned up. And we should not have to deal with that, because that's something else. It requires, the answer to that is not to have more judges, but to do something else. So the nuancing of this, we cannot get unless we have engagement. And I think that would be what I would be pleading for across all of the justice delivery systems. And of course, always from my point of view, to have more and more information in the public domain so that one can nuance all that we do. But again, all of this is toward that. We have Mr. Sunil Chauhan here, who was with NALSA as a secretary NALSA. And between us, my quest for information, his need to have data to put things into his monitoring and evaluation, it was working a dream, really, because he took a lot of the stuff that we needed and made questionnaires. And because it came from him, it was institutionalized for the next report. And it's that kind of collaboration that works best. And it also makes for democracy, because it creates participation between government, between workers of the system, and people like ourselves, who very often are considered to be busybodies. But we're not. Thank you.
Thank you so much for this wonderful address, ma'am. And now it is an honor for me to introduce Honorable Mr. Justice A.G. Masih. Your Lordship graduated in Science Honours, and he completed his LLB Honours from Aligarh Muslim University at Aligarh. He's enrolled as an advocate on rolls of Bar Council of Punjab and Haryana. He also held posts like Assistant Advocate General, Deputy Advocate General, Additional Advocate General, And then he sworn in as additional judge of Punjab and Haryana High Court on July 10, 2008. And then he became the permanent judge on January 14, 2011. So it is an honor, sir. I request you to please address the gathering. Thank you.
Well, firstly, it's a great honor to be here and amongst you all, the people who have been collecting data for us, if you put it that way. That's how I put it. I'm thankful to the Vice Chancellor who has given me this opportunity to be with you all today. Neet, I am thankful because she was the one who introduced me with it. I didn't have any idea as to what are these, this colloquium is all going to be about. So this is what I start with. A person who is supposed to be a judge for 14 years, not knowing as to what is being done by you all. And that's my actually an objection, if you could put it that way. Or you may say ignorance. Or maybe we do get figures, yes. From NALSA, we get it in the legal services authorities. Other data we get even from our courts, from Haryana and Punjab both. Dependency we look at, the nature of cases we look at. We try and find out solutions to that. But let me confess, we have not really worked on the judges as such. Cases, yes. Efforts, yes. To see to it that they are decided. But if you say that we have certain ideas as to how specific cases can be dealt with, or there are certain ways of finding a solution, we do work out depending upon the particular area, maybe a district, on the advice of the administrative judge concerned. But if you say that we have carried out some study on that, we haven't actually done that. This data, which you have collected with you, one, I have doubts about the authenticity, to be very frank, because you would be depending upon the data which is provided to you. How many times have you cross-checked the data? The police, for example, I'm only giving an example. I have no specific details, but over the time, judging cases, being a part of the system, dealing with people who had grievances, coming to courts, experience has been, they're not even heard. They go to the police station, the FIR is not registered. Not even a statement is recorded. And then you say, this is the data available. Well, what about those people who are not even heard? They virtually don't have any, voice, I must say. Then they have to approach some sarpanch or maybe some official who would put a word for them, and then probably things move. This, I'm talking about a situation where the strata of the society is the same. There is no person who is influential on the other side who is actually influencing the police to stop doing it or preventing the police authorities or concerned official from recording that. Why he's not doing it? Because his record, his police station will be reflecting something negative, which he doesn't want. This is what the ground realities are. This study, if could be made, that could actually help us out. We have petitions filed under 156(3). We can help out such situations when we get to know the data. The magistrates would be helping them. They'll know as to what areas are the areas where such situations are happening, and therefore, obviously, they can take remedial steps. Why I'm saying so, there is a reason for that. One, we are not getting the details with regard to the figures at all. Whatever data you have collected, if you have collected from the field, if we really get to know about it, we can have a fairly good idea as to what is happening at the ground level. Well, I agree with Madam Daruwala when she says we don't have time. Yes, we don't have time. 10 to 4 is the court period time. You are there. If you are at the senior level, obviously the meetings are there, then so many things happen and formalities and other aspects do also come in. No excuses for that you don't have time. I'll rather not say that. Despite our all efforts being made, if this help comes to us, we'll probably be in a better situation to handle the ground situation which exists and we are not aware of. Now, as far as analysis are concerned, we analyze things on the basis of the data which you provide. But we don't know how to read that. And how you have reached those data conclusions. What is the input which you have got therein? You get that charts, you get the bar charts. Figures, yes. We understand. But is that the solution? No. Because we need as to what had gone into it to come to that stage or that level. You would have had some benchmark for putting a particular case at a particular level. Maybe mere registration of an FIR could be. Has it been done that in how many FIRs, within how much period of time or the time fixed, the challans have been presented? I'm not talking about the incomplete channels. Because it invariably happens that so that the person does not get default bail, a challan is presented which is half-baked. Because they have an option of putting in a supplementary challan also. But we are not working on that. We probably don't have that details. I would insist, if you could, or whoever is working for you, or whoever wants to associate with the end users, if you could call it, let them really work at the field, at the district level, where we have the data available. The data can be now made available because we are all putting it online. And take it from us, as far as the judiciary is concerned, nothing can be fudged on our part. Because each day's order is uploaded. So there can't be any manipulation on the figures as far as the judiciary is concerned. But we are working on that. At the ground level, at this stage, even we are insisting upon filing at e-filing at the district level. High Court, we have made it mandatory. At the district levels, we already have some districts working on it and actually are into the pilot projects, which we are intending to replicate. So even the petitions would be available and even the replies and the pleadings would be available. Maybe the access is restricted because of the privacy aspect. But with the permissions granted, if the said aspect can be taken care of, that also would be available. Maybe a few more months or maybe 6 months or so. So that shouldn't be an issue provided someone approaches us with a justification as to what is the intent and purpose. Unfortunately, none approaches us. This is for the first time I got to know about all these things. This is at the level which I am over a period of time being a part of the system. Off and on, yes, but a serious thought, if you ask me, has never been given to it at the level where it is supposed to be and required to be. Another aspect which I would like you to please help us out, and in fact can be a great help if you really want the system to work, that's the bar, the advocates. Unless the bar is sensitized, unless they are made aware as to what are the best practices which can be followed, which would cut short the time period for disposal of a case, or the ways and means which can take care of the procedural aspects, avoiding adjournments, that would be a great help for the end result, that is deciding cases at an early time. Because that's one area which, despite our best efforts being put in, we have been successful to a great extent, to the extent of, if you see the number of filing cases filed and the disposals, quantum wise, probably you would see the figure to having gone up. But if you see the percentage wise aspect, there may not be much of a change. Please don't go by the figures alone. Figures over a period of time, and maybe the earlier pendency which was there when the efforts were being made, the artificial intelligence also is now coming in. We are trying to find out ways and means to use that also. But it's at the nascent stage. We are not into it really. The thought process is on. These are certain areas which I just wanted to share with you, which is a cause of concern for me as a judge. I know people are looking forward to us. They have faith in one institution, and that is judiciary. And I think none of us want that faith to go. I feel very happy when the people come up and file cases. That shows at least the faith in the system. I don't discourage filing of cases. I don't want people not coming to courts, because I know they know that there their voice would be heard. They can vent out their feelings. I don't know why the government now has probably realized, but earlier didn't, that the buffer between the government, the executive rather, and the public was the judiciary. It has always been there. Had the people started agitating or reacting, what would have been the position, the lawlessness which would have followed? People would have taken law in their own hands. But still they had faith in one institution. And that is probably maybe delayed, but justice was done. It's always said justice delayed is justice denied. That's right. Probably a person, had he got it, say, 5 years earlier, would have been much more better off than what he now ultimately gets. Quantum-wise, maybe because of the interest is taken care of, but if you look at it, the quality-wise, which he would have actually utilized those, look at the, if you say the money aspect, just see at the quantification. What he could have bought 5 years back, he can never dream of now. Loss, yes. It's never late, and hope sustains. And that's with that motive we start moving, and we are started already. A person comes to the court with a hope. And I'm sure those hopes are converted into results. The end product is the satisfaction. Whether if it's a criminal matter, a conviction, or the other side, if he's wrongly prosecuted or falsely prosecuted, the satisfaction of acquittal. One another aspect which is a cause of concern is where there is a malicious prosecution. It's a way of helping that person who has lost his 3, 4, 5 years down the line till the result with regard to his prosecution had come. Monetary probably may not be enough, my personal view. There need to be something more than that. Since you are people who are thinkers, I would put it to you. Please suggest ways and means to help people in such situations so that it does not happen too frequently. It's quite prevalent. We see the number of acquittals which we get. Going by the figures, I am not only saying that. There are certain cases where, because of X, Y, Z reasons, which I would not like to dilate here, the acquittals do come in, people turning hostile, the witnesses not being traced, or because of non-production of the witnesses also, over a period of time, the court is forced into it. Just one suggestion from the side as far as the judiciary is concerned. Please don't ever put pressure of the number of cases. What happens is the quality of judgments suffer. Justice suffers because of the pressure which is put on the courts. And this is my experience because we have been insisting upon the trial courts to do it fast. And in that, ultimately, at times, the result and the casualty is the justice as such. We are insisting on decisions, but that's not enough. A person who has waited for 5 years merely because a case has come in a particular deadline which we have fixed for disposal of that case, the judge insists upon finishing the matter early. The result would be genuine case may be lost by someone. And if you look at it from the other point of view, a person who would have otherwise got an acquittal because of non-production of his side, he didn't get the time for that. Collecting the data or maybe the evidence, he loses that. Equal opportunity should be given to both the parties. But because of insistence on our part or in the public pressure at times, things tend to happen which we did not really projected or wanted it to be. The result is not the one which is expected. Another aspect. Let's not bring judiciary to be the end product or the resultant, I must say, the institution which is not doing something, as Madam Narwal has pointed out, yes. All are working and they are sincerely working. But there are reasons why the delays occur. Suggestions are invited how to curtail that delay. The ways and means, if you could find one for us. Obviously, amendments are there, which is required, but there are certain administrative decisions which can be taken at the level of the court itself, at the level of the individual judges also. There has to be someone who is to find a way for us. Since you are into it, therefore I am putting it to you. You're working into the details. You're working into the ways and means of helping out a system on which everyone has faith. They're looking forward to it. Especially the one who are weak, unheard, and who have hope. Thank you very much for giving me an opportunity to be here and bearing me with all my ideas, which I have. I didn't intend to actually, in any manner, dilate into the work which you are doing, because that's not my field. I have no idea as to how it works. But this much I can assure you, that if we are given an opportunity of understanding the type of work which you do, the way you do, and for what purpose you do it, probably we'll be in a better position to really make use of the work which you have put in. Thank you very much, and I hope you all success in all your endeavors. Thank you.
Thank you so much, sir. It was a pleasure listening to you. Thank you for explaining the ground realities and being so honest about the system. I now invite our Vice Chancellor, Professor Dr. G.S. Vajpayee, to please present a token of respect to Honorable Justice Mercy.
Oh.
So I also request you to please present a token to the learned session judge. To CGM, sir. Thank you so much, sir. I now request our respected Registrar, sir, Dr. Anand Pawar, to please deliver the vote of thanks. Sir, please.
Thank you, Dr. Rini. I feel privileged in proposing vote of thanks on behalf of Rajiv Gandhi National Law University and also on behalf of India Justice Report to all the individuals who have contributed to make this event a successful event. To begin with, I am thankful to Honorable Justice A.G. Masih, sir, the Judge Punjab and Haryana High Court, for the valedictory address and suggesting the ways and means by which the data can be made more effective and useful for all the stakeholders. And I'm also thankful to Honorable Justice A.G. Masih Saab to always being helpful and guiding source for this institution and contributing a lot for each and every development of this institution. Thank you, sir. On behalf of the university, I am also thankful to the district and session judge, Shri Tarse Manglaji, and the CGM sir, Mr. Amit Malhanji, who always been for this institution. And on behalf of the university, all the participants who have made this event possible, I am thankful to the Honorable Allahabad High Court to nominating the judges who have contributed and participated in this event. All the resource person who have delivered such a wonderful insights to all the participants. To name few, I am thankful to Mr. N. Ramchandran, the IPS retired for Indian Police Foundation. I am thankful to Ms. Neha Sinha, Deputy Director and Associate Fellow at Arts Global. I am thankful to Maitreya Mishra, Head Mental Health and Criminal Justice Project 39A. Sorry. I am thankful to Ms. Radhika Jha, Lead Researcher, Common Cause. I am thankful to Mr. Sanjay Vashist, Member Indian Police Foundation. I am also thankful to Ms. Smita Matt, Research Associate at Daksh, Dr. Sunil Chauhan, former Director, National Legal Service Authority, Ms. Apurva, Vidhi Center for Legal Policy, and all those who have contributed. I am also thankful to our worthy Vice Chancellor, sir, for always being so supporting and encouraging all of us to indulge in various kind of research activities. And within the short period of time, we have achieved much desired target in terms of having more and more research work at university level. I am also thankful to all the coordinators of Center for Criminology, Criminal Justice and Victimology at RGNEB, to name Dr. Indeed, Dr. Shruti, Dr. Guneet Singh, Mr. Ankit Kaushik, and all the student volunteers who have made this event a successful one. I am also thankful to our Deputy Registrar and Administrative Officers, Mr. Siddharth Dahiya, and all the supporting staff and all the participants. In one and all, I am thankful to all. Thank you.
Thank you so much, sir. I now request everyone to please stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड